Hello, everyone. Welcome to the Political Forum. This is our Supreme Court year in review. This is our 7th year conducting the court in terms of the cases for the term that just ended last month. Tonight, we're going to talk about 6 cases. In addition, we'll also have a general discussion about the makeup of the bench and the ideological split and what the future of the court looks like. So the 6 cases that we'll be talking about tonight, the first one is Lange versus the state of California. And this is a classic criminal procedure case where it's really testing the limits of the Fourth Amendment when it comes to unreasonable search and seizures, specifically when it involves a warrantless search in pursuit of law enforcement. The next case involves Ncaa versus Alston, and this involves antitrust violations for college athletes. The third case we have tonight is California versus the state of Texas. It's yet another challenge to the Obamacare regarding what's now the defunct applicability of the individual mandate, which is one of the components of Obamacare. The fourth case is a free speech case, which is entitled Mahoney Area School District versus BL. And this is involving public schools' attempts to regulate off-campus speech by a student. The fifth case we have is yet another First Amendment case involving free exercise of religion. This one is entitled Fulton versus the city of Philadelphia, where here they are really testing the limits of when there is a conflict between religious liberty on one hand and civil rights. And then finally, we have a pretty partisan charged case known as the state of Arizona, the Attorney General for the state of Arizona versus the DNC, as in the Democratic National Committee. And this is a voter dilution case involving Section 2 of the Voting Rights Act with its general provision barring discrimination for minorities. So with all that being said, this is our 7th annual Supreme Court review. And I just want to give you some reference to what our first review looked like. Let's see. Okay, so this was our very first Supreme Court review that was held on June 27th, 2015. Law and Politics, a discussion of the recent US Supreme Court decisions. This covered the 2014 to 15 term. And I remember this term was very legendary because there were a handful of cases for those who observed the court were, quite frankly, landmark decisions. One being Obergefell versus Hodges, which legalized same-sex marriage in the US. There was also another Obamacare challenge that was on the docket for this term. And I also recall there was a First Amendment case involving the display of Confederate flags on government-issued license plate. So this term was certainly contentious. Again, that was back in 2015. And this is what the Supreme Court looked like back then. This is the makeup of the court. And I would draw your attention to the 3 justices that are no longer on the bench. So Justice Ruth Bader Ginsburg, Anthony Kennedy, and Antonin Scalia. And now with these justices who are no longer on the bench, this is what the bench looks like now as of 2021. We have 3 new justices, Amy Barrett, Neil Gorsuch, and Brett Kavanaugh. So as you can see from this photo, the court has certainly shifted to a solid conservative majority court. So typically, when you look at court opinions, because it's a 9-member bench, when there's a 5-4 split, that's considered to be a very, ideologically split decision. I think now, because the balance of the ideological shift has really tilted to the right in a very solidly right manner, I think 6-3 is probably the right way to look at whether if the opinion by the court was very divisive. So I was able to look up some stats thanks to SCOTUS blog. And what's really notable about this term is that we did not have very highly contentious, 5-4 or 6-3 split. So when we take a look at the next graph here, there are surprisingly quite a few 9-0 or 8-1 cases. I know the color scheme is not the best here, but about 29 cases from the docket, which represented about 43% of the cases, were a unanimous 9-0. Likewise, we had about 10 cases representing 15% of the cases on the docket that were 8-1. And what's really noteworthy here is that for those who are followers or observers of the court, whenever there is a 9-0 or 8-1 split, I think the opinion has a higher level of credibility because it's not viewed with kind of like a partisan lens. What's also notable here is that the 6-3, which is the true ideological split, only represented 16 cases, which is 12%. So, and then 5-4 was your classic split. But again, that's kind of misleading now because of the shift in balance of the court. And as you'll see here, in some of these cases, you had 8-1/7-1 or 7-2/6-2. What that indicates is some of the justices had to recuse themselves because they had some kind of conflict of interest. It's my understanding that Justice Barrett, because of her previous role as being a law professor, as well as sitting in the Third Court of Appeals, had to recuse herself in some of these opinions. Now, what's also remarkable is that the conventional naming of the court is often referenced by the name of the Chief Justice. So for instance, it's pretty obvious to say that this is the Roberts Court because Chief Justice is John Roberts. And prior to that, we had Justice Rehnquist as the Chief Justice. So it was the Rehnquist Court. But a lot of the followers of the court will point out that the true pivotal judge, or justice rather, on the bench was Justice Kennedy up until his retirement. So for the last 8 to 10 years, it was really the Kennedy court because he played a very instrumental role with these very split decisions. Now, if you look at this chart here, again, it was obtained from SCOTUS blog, you see that this bar graph represents the number of majority opinions that these justices contributed to. And what's really remarkable is that Justice Kavanaugh was 97% of the times he joined in on the majority opinions. I guess what's remarkable there is that the nomination process was highly contentious. It was super hyper-partisan, and by most estimations, it appeared that Justice Kavanaugh was going to be a bit more, I guess, dependable, partisan type of justice. Well, at least based on his record here, it seems like he was a bit more independent in a sense that even when there was a right-leaning opinion, he was not necessarily the majority opinion, but he would concur with the opinion or be part of the opinion that was not joining in on the major ruling of the cases that we had. So again, 97 is a very high number. Take a look at John Roberts, 91%. Now that's kind of remarkable because prior to this term, Justice Roberts was viewed as being a more instrumental swing votes. Here, his opinions were only 91% of the majority. So again, you could see a dip here with Justice Roberts having less influence when it comes to kind of coalescing different justices to reach the opinion. The next graph again shows Justice Kavanaugh being 95% of the opinions when the opinions were divisive. And what do I mean by divisive? Whenever the opinions were either a 6-3 or 5-4 split, again, Justice Kavanaugh joined in on the majority 95% of the times. What's also notable here is that on the left end of the spectrum, Justice Sotomayor, 45%. Again, 45% when there was a split and she joined in the majority. So what does that indicate? That trend indicates that a lot of the opinions from the court are center right or just very conservative. So when you're looking at the makeup of the court, you're probably wondering, well, what is the state of the liberal wing of the Supreme Court? Well, the next graph will illustrate that Justice Sotomayor is becoming a very, being very influential in her role as being the sole staunch liberal on the bench. This graph here, bar graph, represents the number of majority, concurrence, and dissenting opinions. And as you can see from this bar graph, she had the most dissenting opinions that she had penned. In fact, if you look at the color scheme, there's more yellow than green or purple. So what that indicates is that because the majority of the opinions that came out of this court during this term tend to be conservative, Justice Sotomayor was on the opposite end, on the liberal end of these opinions. And a lot of times she was the sole dissenter. And we're going to see that when we read the Arizona Voting Rights Act case. So that kind of sums up just the overall trend, the makeup of the court, and what we saw in terms of the opinions. And then I'm sure a lot of people are wondering, well, what's going to happen with Justice Breyer? So why don't we take a few minutes now and just, I want to ask the attendees here what you think the future of the court's going to be with this, possible or gossips of Justice Breyer's retirement. Do you think now's the right time to retire? Should he wait until maybe next year? Any thoughts on that? Okay, well, I guess I'll get started. Yeah, good.
But I think that, even though he's a very well-trained lawyer and then a judge, especially in international law, I think he has a very strong preference for international law. So I would hate to lose that perspective on the court when he has such a strong background in international law and such a passion for it that may be lacking among the other justices. I do understand the point that is made by a lot of liberals that he we don't want another situation like Ginsburg. What happened with Ginsburg, that she just waited too long and disaster ensued if you're a liberal after her death. And Breyer is not liberal, as you say, as much as Sotomayor. He's more like center left, if we can call it that. So this is a golden opportunity if he does retire for Biden to pick someone who is more liberal than Breyer is, but maybe in the same school of thought about judicial philosophy and whatnot, because we really do need a more stronger anchor. We can't have just one liberal being the anchor for the liberal wing of the court, especially when it's so lopsided. We need just more passionate liberal justices if you are someone who believes that we need that kind of counterbalance, which is right now out of skew with where the court is going.
Right, and I think the dilemma that those on the left are concerned about is the fate of Justice Ginsburg, because back in 2014, there was a lot of murmurs about her potential retirement, but obviously we know what happened. She decided not to retire, and I guess just looking at it surely from a partisan angle, if Justice Breyer does not retire this year, well, next year we have the midterm elections, and right now we have a very narrow Democratic Party-led majority in the Senate. It's 50-50 split, plus the vice president as the to cast a tie. So if the balance of power shifts back to the GOP, then I think that could be trouble for the Democrats in the sense that there could be some kind of a block to get another nomination in. So that's certainly, something that we are watching. I mean, I've been following Justice Breyer's career for a long time, and it seems like on one hand, he's very bored with being a Supreme Court justice. Yet on the other hand, he's very prolific in terms of being on the lecture circuit. I think he just published a book recently.
Yeah, and about a national law. Yeah.
Yeah, that's right. Yeah. So I'm not sure exactly what his future will be, other than usually when Supreme Court justices announce their retirement, they do so right after the term concludes. So, just going back to the previous retirements, again, Justice John Paul Stevens or David Souter, they announced it right around this time saying that, okay, I'm done, I'm packing up my bags. Please don't send me any more law clerks. I'm going to shut down the office. But we're not seeing that from Justice Breyer. So, okay. Anything else on the potential retirement or lack of retirement from Justice Breyer? I guess we'll move on.
Well, I mean, I think maybe we'll discuss this later, but maybe we should also discuss this idea of packing the court and all that other, talk that's been going on as to whether it's a good idea, bad idea, term limits, for Supreme Court justices, maybe elections for the Supreme Court justices. These are all things that, given the huge skew right now in the makeup of the court, are becoming more prevalent talk among the public.
Yeah, that's a good suggestion. Although that's kind of like a topic in and of itself, just because there's so many proposals. I know that the current administration is putting together some kind of like a blue ribbon panel to look at some of the reforms, but I'm not sure if that's going to go anywhere. All right. So again, before we dive into the 6 cases, I just want to make some general comments about my observations of the court based on the ruling. So I think what this term showed is that it's a very center-right leaning court. Some commentators think that it's a very moderate court, or some commentators say that, well, it was the Roberts court, but now it's shifting more into the Kavanaugh court. I think that still remains to be seen, because you have to keep in mind that Justice Barrett has only been on the bench less than a year, and I'm not really sure if we have seen her ideology really develop. Is she going to be more of a Antonin Scalia type of jurist or something else? My guess is yes, she's more of a Justice Scalia jurist, but again, being on the bench for less than a year, we haven't really seen everything develop. The other thing that I noticed about this term is that it wasn't as contentious as the previous terms, where you have like the Obamacare challenge be decided on an election year, or same-sex marriage, or those kinds of cases, or abortion case for that matter. This term, I thought it was more mild than the previous terms in terms of the hot-button issues that the court had on its docket. I think this is more like a transitional period where, because of the balance of power of the ideological makeup of the justices, they're starting to kind of, build some kind of a coalition behind the scenes. And one thing that this court did really pronounce that was very noticeable is that it's a very pro-First Amendment court. And it's very pro-First Amendment in terms of religious liberties and free speech. And there are actually 2 cases that we're going to get into later, one being Fulton versus the city of Philadelphia, free exercise of religion, and then the one involving high school cheerleader in terms of free speech. One other thing I'll note about this term is that we've seen this emergence of what's called a shadow docket. And I'm not sure if anyone is familiar with that. But typically, if you wanted to take your case all the way to the Supreme Court, you would have to follow the proper procedural channels, either petition for the writ of certiorari or have the case be based on, let's say, state of Texas versus California. When two states are litigating against each other, then the Supreme Court becomes the original jurisdiction. What we've seen recently is that there were a lot of these kind of shadow dockets where certain emergency applications are made right to the court, and they decided without legal briefing and without oral arguments. And this was noticeable with Governor Cuomo in the state of New York, who instituted certain mandates during the height of the pandemic, and you had certain religious institutions make an emergency application with the court to seek an injunction, and the court just decided on the merits, but without legal briefs or oral arguments. And you can make an argument that that's acceptable, perhaps in a time of pandemic, but if this is the trend that we are seeing with the Supreme Court cases being handed down without any transparency, I mean, that's highly problematic. And I mean, this is not an ideological statement. It could work both ways, but you certainly want the court, their job is to set precedents and interpret the law. And once they're more of a fact finder and just deciding these cases as they see fit, then, well, guess what? That could lead into a lot of decisions that are very arbitrary or capricious, which, again, the court will say that that's unconstitutional. All right, I see a hand up from Ncaa. You want to say something before we move on?
Yeah, it was just wanted to ask something about what you said earlier about this session not being that contentious. And you presented some statistics earlier about how many of the cases were 9-0 or 8-1. And I recall when seeing statistics like that, that even during contentious sessions of the court, there tend to be a lot of those almost unanimous or fully unanimous decisions, just because there are a lot of cases that are I guess, don't split along ideological lines, or at least not the standard left-right lines. And similarly, I wanted to ask about what you said earlier about Sotomayor in terms of being on one end of the spectrum, but and she only signed on to 45% of the majority opinions, but 45% seems kind of high for like the 5-4 decisions if those decisions are splitting along ideological or left-right lines. So does that imply that there are a lot of 5-4 decisions that are splitting along different lines?
Yeah, so I guess I'll address the second question first. I guess not every case is ideologically driven. Sometimes when you're dealing with certain, dense federal statutes or criminal procedure, which we'll get into next, it's not as ideological. And a lot of these like First Amendment cases tend to be a bit more slam dunk. So you get a lot of these, 8-1, 9-0 cases. So whenever, let's say somebody like Justice Sotomayor, who has the lowest percentage of the majority opinion, that doesn't mean that, the 45% that she joined in were highly contentious, because a lot of these were, 8-1, 9-0 opinions.
Wait, was the 45% among all opinions or just among the contentious ones? I thought you said it was just among the contentious ones.
Yeah, so the last graph showed, let's see, 45% of the contentious. Yeah, you are correct. So the ones that were 6-3, 5-4 shows 45%. So that is correct. However, even within that realm, the ones that she joined in, if you look at purely based on the vote count, it might seem contentious, but a lot of what the Supreme Court does is, they look at a lot of the administrative law type of statutes, or they'll look at, criminal law in terms of the 4th, 5th, 6th Amendments. A lot of those tend not to be so contentious. So when you look at the vote count, it might seem split, but the issue itself is not like left versus right, as the media would portray it. So that's what I would say about that. And look, I mean, the bottom line is, when Justice Ginsburg passed away, I think the observers of the court were wondering, well, who is going to replace Justice Ginsburg? Again, Justice Ginsburg has been so influential on the left side of the bench that, I think those who are watching the court was wondering, would it be Justice Kagan or Justice Sotomayor? And I think Justice Sotomayor certainly rose to the occasion. Just like when Justice Scalia passed away, again, he was an ideological giant on the right. In some ways, you could say that Justice Ginsburg and Scalia were kind of like the ideological counterparts against one another. But now you've seen kind of the emergence of Justice Gorsuch as possible, ideological replacement or successor, rather, of Justice Scalia. And perhaps that could be both Gorsuch and Kavanaugh. So, but that's a good question. I'm sure if you go through all the stats, it's probably more revealing, and I'm sure we could have like inside the baseball type of statistical analysis. But I am a bit of a semi-casual observer of the court too, so I don't know all the ins and outs in terms of the behind the scenes that go on at the court. But yeah, that's certainly worthwhile to note. And I guess the other thing I'll mention too is that I think the number of cases that they heard this term were less in terms of the number of cases than the previous year because of the pandemic. Just the logistics of arranging oral arguments were just tough because everything was done by phone. So I think by next term, if the court does reopen, you'll probably see more cases, probably to a tune of 70, 80 cases or so. And there you might really get a more definitive trend. So I agree with Nirav's observation is that you can't make too much out of these trends. I mean, these are just pure statistics just on this term. And sure, this term is certainly exceptional in a sense that we're still in the middle of a pandemic. We have a new justice, Amy Barrett, who has been on the bench for less than a year. So it might be more like an anomaly, or maybe it's just like a snapshot in time that's not the most representative. So why don't we go on to the first case? And it's Lange versus the state of California. And as I mentioned before, a lot of what the Supreme Court does is decide cases based on 4th, 5th, 6th Amendments. 4th being unreasonable search and seizures, 5th Amendment being the right not to self-incriminate, and the 6th Amendment being the right to counsel when you are detained. And by the way, these rights are codified in the Miranda warnings when you see these TV shows. So this case involves what's called a hot pursuit. And to me, I find these cases to be interesting because it's something I could relate to, right? It's kind of like, when you're at a party, cop knocks on the door. Well, do you need to open the door or can you just ignore it, right? I mean, it's that kind of situation. And I think many of us might have been in that situation where, well, I don't really know what the right thing to do is. What are my rights versus what can the law enforcement do? So the fact pattern is fairly simple. Mr. Lange one day decided to, blast music in his car. He was honking the horn, and it was very clear that he wanted to attract attention. It also turned out that he was intoxicated, and the law enforcement, followed him all the way to his house. Then he got inside his house, and the cop had reasons to believe that Mr. Lange was under the influence. Now, by the way, being under the influence in some jurisdictions is not necessarily a felony. It's more like a misdemeanor. And here, I think in the state of California, it was a misdemeanor because it's driving under the influence. It's more like a traffic violation rather than a criminal violation. So the issue came down to whether if the cop can just go inside Mr. Lange's house without a warrant in this hot pursuit of detaining Mr. Lange to get additional evidence. And this is what the doctrine of hot pursuit is, because the idea is that when you just let the person that you're chasing let go, then some evidence that you might want to collect might just be gone, or these are called the exigent circumstances. So what that means is, in some instances, it's just too fast moving of a target to call the magistrate judge and get a warrant. So you just have to kind of act, think on your feet and act quickly. And here, the court said it was unconstitutional for what the law enforcement did, because, again, it's hot pursuit based on a misdemeanor offense. Again, driving under the influence is not a felony, it's a misdemeanor offense in the state of California. So they said, well, you could have had the time to get a warrant and then go inside his place to do the search and seizures, and then, if needed, arrest him. But here, they do not do that. So that's kind of the gist of the case. But to me, these cases are fun to read because, these are the things that you see on TV shows. And also when you're at a social gathering, these stories always come up. One interesting thing I want to point out, and the reason why I love reading these Supreme Court cases, is they really kind of spell out how these doctrines were, how these doctrines originated. So here they're talking about page 4 of the opinion. They talk about the origins of the castle doctrine. And the idea is that when you are inside your home, you are in your castle. And therefore, for the government to come in and intrude upon your person or your personal effects or papers, well, there has to be a compelling government interest. And government has to then make sure that you, as the castle, the owner of the castle, or the king of the castle, if you want to put it, your rights are not violated. So what the opinion here does is it goes back to the old English common law. And then they dug up this, I guess you could call it a legislative session back in 1763. It's a parliamentary debate. And here's what it says. The poor man may in his cottage, hold on one second. The poor man may in his cottage bid defiance to all the forces of the crown. However, even though the roof might shake, even though the wind may blow through the roof, even though the storm may enter, even though the rain may enter, the King of England cannot enter. And what that means there is that this is in the context of enforcement of collection of taxes. And for them to just knock on someone's door to collect your taxes, they're saying, no, you can't just go into someone's house, barge in and demand, payment on behalf of the king. Why? Because there are certain safeguards in place. And if you want to do that, well, you better get a warrant and follow the right steps. So what this paragraph illustrates is whatever calamities, whether if it's wind, storm, flooding, those things might intrude upon your property. However, no king, doesn't matter if you're King George or no one else, has the authority or the audacity for that matter, just to barge in and seek government action. So it's really notable that this court mentions this legislative intent going all the way back to 1763. And what does that mean? It indicates that the court is still upholding a lot of the safeguards from the Fourth Amendment. And that's been the trend for at least the last 15 years under the Roberts Court. We've had cases involving smartphones and privacies, and also certain other unreasonable search and seizures. And the court has consistently said for the government to act upon this type of search and seizure, they must follow the right protocol. So I think this is, most court observers will agree with the ruling here. And if I'm not mistaken, this was an 8-1 opinion. So again, a lot of credibility there. Anything on this Fourth Amendment case before we move on? Okay. All right. The next case involves the NCAA, and the caption of this case is NCAA versus Alston and others. So this case really touched on two issues from my standpoint. One thing to think about, when we watch college sports, I mean, it's very competitive, depending on which division, but still, it's a very competitive environment. So you have to think about, well, are the college athletes, are they professional athletes? Some will say yes, others might say no. I think NCAA will say, no, they're just amateur, athletes. They are trying to, perfect their skills so that they could go into prime time. That's certainly debatable. This court did not buy that argument that college athletes are non-professional, meaning, there are certainly, professional athletes generating tons of revenue for the colleges. And then the second issue is more kind of a technical issue from a legal standpoint, which is when basically the manner in which NCAA operated, are they still subject to antitrust laws, notably the Sherman Act? And the court here said yes, unequivocally, that NCAA as an enterprise should be subject to certain antitrust law protections and requirements, rather. So I guess the facts are fairly simple. You have these college athletes who, they're the star players of their colleges. They generate tons of revenue. I'm sure we've seen ads for March Madness. It's a very lucrative market, yet these college athletes are not paid anything. They're not reimbursed for their skill or talents. But here the issue was not so much the direct cash payment to the college athletes, but these were called the non-cash educational related benefits. So what does that mean? Things like scholarships, internship, equipment, computer, etc. So the non-cash payments that these athletes sought, they did not get from NCAA or from their colleges. And because they're not getting that, well, should there be a more heightened level of review to see if NCAA is violating the Antitrust Act? And the notable thing here is Justice Kavanaugh's opinion. And it's a concurring opinion by Kavanaugh. And basically he says, if any other business in the US did what NCAA did, they would be subject to antitrust violation because they are, after all, a private organization, private enterprise. They are probably a billion-dollar industry. And for them to say that, oh, well, look, we're just, a nonprofit organization. We support, college athletes, and we should not be subject to that. This court did not buy into that. Another colorful argument that the NCAA made is that, look, these athletes, they're very talented, but they really love what they do. If you're a basketball player, you really love it because it's been your lifelong passion. Now here you are playing ball, center of the most prominent NCAA team, and they're just doing what they love. So why should they then get paid for doing what they love? And again, this court didn't buy that. In fact, there's a very scathing opinion from the court saying that, well, if that's the logic that you want to use, that means every baker in the country should just get paid lower than minimum wage because they love the art of baking. You wake up in the morning, smell the croissant, and that is your life thrill. So why should you get paid regular hours? And he goes down each profession by profession. If your job is a doctor, well, guess what? Your job is to heal the people, heal people, make sure they feel better. And if that is your pure reason for existence, then why should they get paid market wages? And he goes down the list with all these other professions. And he's saying that the athletes are no exception. They are just like any other individuals with skills, and they're doing something beneficial for the organization. So they should not be exempt from the antitrust laws. So that's really the gist of the argument. And in the end, they really, are very critical of NCAA because they equate this to almost like a price fixing. So again, these athletes are artificially not compensated or just compensated at a very, very low rate that it's akin to price fixing. And that is not acceptable in the scheme, in the system that we have. So that's pretty much the crux of the opinion. One thing that's left unaddressed, and again, this is where I think I mentioned before at the head of the event that this is a very incremental court. It's very moderate in some sense because they're not looking for like oversweeping opinions. They're not looking to overturn Roe v. Wade overnight. They're not looking to just get rid of affirmative action in 1 year. I think they're doing things incrementally. And you'll see that when we get to the city of Philadelphia case on religious liberty, it's like this kind of incremental approach. Here with the NCAA ruling, they talk about whether if, again, non-cash contributions or reimbursement violates the antitrust, that being things like scholarships and equipment, but they did not address whether if it's okay for there to be limits on cash payments to NCAA athletes. So I think this is a case where it's going to get brought up again because now they're going to allow these NCAA athletes to get paid, whether if they get paid six figures or maybe even $1 million or plus per year. I guess that's up to each contractual provision. But now, can they come back and say, well, we got to put a cap because a lot of these athletes are, maybe very young age, maybe they just, turned 18, and they could certainly make an argument that, well, they're still students technically, so they shouldn't be making this kind of money compared to the rest of the students on campus. Just one last thing I want to point out about this opinion, and this was really the surprising thing, because again, when you think of Justice Kavanaugh, based on the previous, the nomination hearing, it was a very contentious, hyper-partisan appearance. But in his concurring opinion, he actually points out that, look, and this is on page 4 of the concurring opinion, look, if you look at the makeup of the NCAA athletes, quote, many of them are from African-American and lower income backgrounds, and they have little or nothing when they first come to NCAA. So shouldn't the aim of these organizations then to empower these athletes so that, yes, they get an education, hopefully they graduate with a degree, and B, compensate for their skills. And I think Justice Kavanaugh makes a very persuasive argument there. And again, it's really surprising that that train of thought came from Justice Kavanaugh, because that's something you would maybe see from the likes of Justice Sotomayor or Kagan, but that's Justice Kavanaugh's concurring opinion. So before we move on to the next case, anything else on the NCAA case? Okay.
No, I just want to say it's about time.
Okay. So that's it. That's Tara, I guess.
Yes. Hi, you guys. Hello, everybody.
Hello. So that means, I guess, cash compensation, fair game, right?
Absolutely. The NCAA signed a $1 billion contract with Turner Media a couple years ago to broadcast March Madness exclusively on all Turner Media channels. So TNT, TBS, True TV, and something else, I think CBS. It seems absolutely wild to me that a student used to be punished for taking something as simple as a chicken sandwich, like a free chicken sandwich, if someone wanted to give it to them. Coaches weren't allowed to have students over at their houses for just like a meal. And keep in mind, a lot of these athletes, especially D1 sports, football, basketball, baseball, soccer, hockey, etc., their their school schedule combined with their athletic schedule leaves absolutely zero time for actual jobs outside of that. And so while other students are able to maybe have a scholarship, but also work on campus or off campus, those athletes, male and female, don't have that luxury of time to be able to go out and source a job, to have extra funds on hand in the event that their scholarship doesn't cover everything. And so you had athletes who are playing in March Madness, but are going hungry in their dorm rooms. And they weren't able to, again, they couldn't even take a sandwich if it was offered for fear of losing their scholarship, for fear of losing their eligibility. And so I just think that it is high time that they are able to profit off of their own name, image, and likeness, just as much as the NCAA has been doing for over a decade.
Right. And another, I guess, kind of uncharted territory in terms of NCAA is going to be once, now that we have this ruling where it kind of lifts a lot of the restrictions on NCAA, you have a lot of these, superstar athletes. I mean, the future, the next Kobe or, next LeBron, they might want to trademark their brands and they might want to get into endorsements. And again, can they do that? And right now, that question is unanswered by the court because there are some restrictions by the NCAA. And I did read a response from the NCAA president. Basically, he kind of gave this like wishy-washy response saying that, well, we need a proper legislation. We want Congress to deal with this issue because if the athletes demand fair pay, et cetera, then maybe there should be some legislation. Well, I guess that's all fair and good. Although I guess from the athletic standpoint, it's a little too late now. But I think in the future terms, you're going to have these cases come up again, where I think the court's going to have to really decide: are these athletes, are they professionals or are they amateurs? And the court didn't really touch that this time. They just simply ruled it on the grounds of the Sherman Act, which is antitrust laws. But I think this issue is going to come up again. Again, that's the incremental approach that we're seeing with this court. Okay, there was a hand up from Kim. Hello.
Yes, hi. Yeah, I completely agree with Tara that it's about time these kids are getting, not in trouble for taking a meal. I think it was last year, the year before, a kid got in trouble because he sold a picture of himself with a signature on it. Like, that's just ridiculous. Now, my concern is going to be to see what happens in the future. If the NCAA continues in this greedy kind of pattern that they've had, are they now going to try to get money out of the schools, which is then going to raise tuitions for the kids, and including other kids that aren't in sports? So I'm going to be interested to see what the, I'll say, fallout, for lack of a better word, is with all this stuff. But I do agree, it's about time that the kids didn't get in trouble for, silly things like having a meal, which has happened.
Yeah, and I mean, that's an interesting, I guess, proposition, because if the schools were to raise tuition because now they have to compensate these athletes, well, I think the NCAA is trying to have it both ways. On one hand, they're saying, hey, we're just like a nonprofit organization. We're letting these athletes flourish with their natural talents. Please don't, regulate this market. On the other hand, if they say, well, hey, we want to increase the tuition, and then you have a lot of these students who are saying that's unfair because, the tuition hike is unreasonable. And then the NCAA and other colleges are going to say, well, we should be subject to antitrust laws because, at the end of the day, we're just a college and, we get to do what we want to do. We could raise, tuition based on supply and demand. So I think they're trying to have it both ways. So if that argument does come up, it'll be interesting to see if they do like a 180 from no regulation, that's being very pro-regulation. So one more from Tara.
The NCAA and President Mark Emmert in particular have been kicking this can down the road for a very long time. This was a conversation, even 20 years ago, when Reggie Bush was playing for USC. Because Reggie Bush lost his Heisman because of, I forget the exact details, but something along the lines of he took money from someone, sponsorship type of deal, and they took his Heisman from him. So they've been kicking this can down the road for a very long time, but as it stands right now, what they are allowed to do, the athletes at least, are to get at least sponsorships. So it's not that the schools are paying them, and it's not that the NCAA itself is paying them as of right now. That is the part of the can that they're continuing to kick down the road. But they can get sponsorship deals now. They can, accept a free meal. They can do things like that. As far as the schools don't pay the NCAA pays the schools. It's in reverse. So because the schools are like part of the NCAA, but they don't pay money into them. So I'm not sure how that would work as far as tuition and things are going to go, but I highly doubt that the big schools, the big name schools, the Alabamas, the Floridas, the USCs, the Michigans, the Notre Dames are going to see much suffering in the way of their athletic programs. As far as right now, their ticket sales, they sell merchandise, all of these things. These places are pretty well shored up. It's the lower schools that you probably have to worry about more for right now. The D2 schools, the D3 schools, those.
Yeah, thanks for those comments. I guess if there's no other comments, we'll move on to the next case. The next two cases involve the First Amendment. So this one is on free speech, and the one after that is on free exercise of religion. So the next case is entitled the Mahoney Area School District, which is in the state of Pennsylvania, versus BL, a minor. And the fact pattern is fairly simple. A sophomore in high school tries out for the cheerleading squad, and I believe that she did not make the varsity team, but she made the junior varsity team, so she was upset. And she did what most teenagers do, which is to express their frustration on Snapchat. And that's exactly what she did. She found out that she was not accepted to the varsity team. So then she, I think, was off campus, maybe either at home or maybe at the mall. And she posted some vulgar language on Snapchat, basically saying F this, F that, with plenty of middle fingers tossed around on Snapchat. Now it turns out that the cheerleading coach got wind of this somehow. Maybe it was reposted or there was a copy of it, of the posting on Snapchat, and they decided to discipline this student who was a minor at the time. And they told her, well, look, because what you did, we're going to discipline you, and you're not eligible to try out for the cheerleading squad next year either. So obviously she was upset, but because she was a minor, her parents filed suit saying that her free speech rights were violated under the First Amendment. In this case, did go all the way up to the US Supreme Court. So that's kind of where we are now. And before we kind of dive into the case, it's really worthwhile to explore, what constitutes on campus versus off campus. Like, I know the conventional way of looking at it is pretty simple, right? Because, it's basically when you're on the premises of the school or the institution, well, you're on campus. But I think in the modern era of social media, what constitutes on campus is very murky. And I think this opinion really touches on that too. So that's something to think about. And then before we get into how the court reached its final ruling, they do talk about some other previous precedents. So there's a very seminal case from 1965. It's called Tinker versus Des Moines Public School District. And what happened there was in 1965, it was at the start of the anti-Vietnam War demonstrations. So you had these young children, I believe they were probably like grade school age. They displayed anti-war protest signs at school, and the school prohibited those signs because they found those anti-war signs to be very disruptive, and it could be detrimental to other students. And there, what they did back in 1965 is they used what's called the best interest analysis to determine whether if the school's actions were proper because of the best interest of the minor school children. there's a very well-established doctrine called in loco parentis doctrine, which is Latin for when certain officials or authorities kind of step into the shoes of parents, meaning sometimes when these children are entrusted with, let's say, school or other organizations, well, they kind of step into the shoes of the parents temporarily for the sake of safeguarding their interests and then also looking out for their best interest. So the court opinion in Tinker has a very famous quote that says, on one hand, when children arrive at the gates of the school, they do not shed their constitutional rights of First Amendment. Yet, on the other hand, the courts do not have a unfettered or unlimited authority to restrict students' rights of free speech. So there was, a bit of a, back and forth in terms of the competing interests. There was also another case, I believe, about 15 years ago. Some of you might remember this. A student in a rally had a sign that said, quote, "Bong hits for Jesus," right? Because this student thought that that's what Jesus needs, some bong hits. So they portrayed this sign, and because the school disciplined this student, he alleged that his First Amendment rights were violated. Again, the court upheld it because it's a constitutional speech. So again, in the recent years, the court has been very deferential in terms of upholding free speech. So what's interesting here is that this opinion was authored by Justice Breyer. And I know Ali had mentioned that Justice Breyer is certainly notable when it comes to certain areas of law, international law being one of them, but also when it comes to First Amendment issues. He's very deferential to the First Amendment. And basically here, what he's saying is that, look, let me just go through the analysis. First of all, there's what's called the fighting words doctrine. So meaning if you say something that's going to incite violence or what amounts to like some kind of confrontation, that's not protected speech. It's case by case. But if you're going to incite violence, then usually courts are not as protective. But here the court said the social media posting that this student did not really amount to fighting words. So they struck down the school's allegation there. The second, I guess, analysis that the court does here is that because this social media posting happened outside of the school setting, again, I think she was either at a mall or a convenience store, this concept of in loco parentis did not apply, meaning the parents of this minor child did not have any expectation that the school is going to just step in and act in the child's interest. That's number one. Number two, even if you put forward this argument that, well, look, when a student is at home or away from school, or when she's on social media, when her message could be reachable to others who are members of the school, then, well, the school has some compelling interest to regulate that speech. And Justice Breyer does not buy that argument, because if you use that logic, that means the court essentially has a 24-hour virtual authority over the child, whether if they're in school from 8 to 4 p.m. or when they're at home on social media. So the court said, no, we're not going to buy that. The court does not have, the school does not have this kind of perpetual, unfettered authority to discipline the child. It's a very limited scope that the school has. And then finally, Justice Breyer uses this very kind of artful description to say that, look, and I'm quoting here, because America's public schools are the nurseries of democracy, we have to allow some harmful speech to take place. Nurseries of democracy. So on that basis, he struck down the lower court's ruling, which held that the school was permitted to discipline this minor child. There was a lone dissenting opinion here by Justice Thomas. And whether if you agree with this or not, I think it's worthwhile to at least take notice of it, because what Justice Thomas does here is that look, in the age of social media, we can't really distinguish what's on campus versus off campus, because again, you could be off campus using Snapchat, but you're reachable to the rest of the school community. So now, by the virtue of being on social media, you are quasi, present in the virtual school community. So he kind of uses that argument, and he's saying that it's a case-by-case determination, but with the advent of technology being prevalent in our society, it's time to rethink what constitutes on campus versus off campus. And I guess just a footnote to this case. So at the time when this lawsuit was initiated, I think this student, BL, was like a sophomore in high school, and now she's 18 years of age in college. So the court could have said, look, she's 18, she's an adult, there's no more live controversy. They could have just simply dismissed the case as being moot. And the Supreme Court does that a lot. But here, they didn't do that. They decided to take up this case, and they gave a substantive ruling. So, for those of you who are, pro First Amendment free speech, this is certainly a case that you could rally around. Okay, so any questions or comments on this case? Let's see, Andrew and then Ncaa.
Hey. Yeah, so based on the case, you said they're basing this off of if they were like in the shoes of the parents again, because I'm just thinking in a circumstance of, let's say if like a company finds something inappropriate from like an employee, that this case will probably be looked in the same way compared to the one you were just talking about. I just want to make sure if I heard that correctly, if they were just taking the stance of like, let's say a parent with a child.
Okay, that's a great question. And I know those kinds of, hypothetical questions get tossed around a lot in the First Amendment context. So there's, I guess, two variables that are embedded in Andrew's question. One is, again, private company versus a public school. I think private companies have a lot more latitude to regulate its employees, as long as they don't discriminate based on certain provisions of Civil Rights Act, et cetera. So that's one point. Second point is when you're dealing with company versus its employees, it's different than parents versus children or school versus children, or vis-a-vis children. So I think the relationship setting would give more deference to private employers with this employees versus school parents versus the children. So I guess if your hypothetical is suggesting that, well, if a private company wants to regulate the speech of its employees, can they do that? I think that's kind of the question. I think it really depends. A lot of these First Amendment cases are case by case, situational. I mean, I know some companies, they have a policy, you cannot, use communication devices on certain, weekends or holidays because, religious observance, traditions, whatnot. So that could be challenged too. But I think ultimately the employers will prevail there because, it's a private company, and, unless if there is any kind of like a discriminatory intent to target certain people that are protected under the law, I don't think that would be actionable. Did that answer your question, or?
Oh, this like it. So this is like, is this the public school or private? So this will go across the board, even if it's like a private institution.
No, private institutions, that's a whole nother ballgame. Because it's private in nature, they're given more latitude when it comes to their action, because private institutions or private schools, it's not a state action because they don't receive government funds to operate. So unless, I mean, you do have some of these like quasi, private public schools like the charter schools. And that's kind of a gray area, but by and large, if you're talking about like a parochial school, I think the court would come down and say it's a private institution and they're given more latitude to discipline and regulate their children. So this doctrine of in parens loci would certainly be upheld, greater as opposed to public schools. Okay. Let's go to Nirav, has his hand up.
All right. Question about the case. I recall in the arguments for the case, the school district was arguing that there were other concerns that could potentially come up. So one was cheating on tests, and another was bullying, where the school would have an interest in regulating students' speech regardless of where they were. Even off campus, and especially during the pandemic where everyone was off campus, that cheating in particular and also bullying would be impossible to regulate if the court ruled entirely in the favor of the student. And I remember reading that in the majority opinion that the court did address those points, but I want to say they kind of punted to say that yes, the schools have some interest in that, but that's kind of a separate matter that we're not addressing. Is that correct, or were they more specific about that?
Yeah, you are absolutely correct. And thanks for pointing that out, because in the dissenting opinion by Justice Thomas, he does point out that, look, we live in an era where children are bullied on social media. So cyberbullying is a real thing. In fact, it's probably more intense than regular bullying. So he does point that out, but it seems like the majority ruling kind of just glossed over that point. And usually what happens in a lot of these cases, again, you have two competing interests. You have the school's interest to discipline or regulate student behavior, and then you have the protected interest of the student, most notably the First Amendment. So what the majority opinion is saying is that when those two interests collide, well, we have to err on the side of the student's interest, because yes, the school might have some legitimate purpose of curbing, let's say, cheating on exams or cyberbullying, but there are other ways to go about that. And if they want to really address that issue, well, address it other ways instead of trying to restrict one's speech. And the thing is, once you start restricting it, then I think you could certainly make a slippery slope argument that, well, if they could regulate, cheating on tests, cyberbullying, well, what about, curfews, or what about, I don't know, vaping? I mean, you could just go down the list, overuse of smartphones. So I think the court is very wary of not, issuing an opinion that is so oversweeping that it's going to have a tremendous effect, with a large magnitude. So, but that's a very good point, though. And I think Justice Thomas clearly articulates that view, which the majority does not really, pay too much attention to.
So what would the majority have a school do for, let's say, preventing cheating or addressing cheating or bullying?
Sure. I mean, I guess there are a host of measures that they could take. For instance, if it's cheating, maybe have proctors, maybe have design the exams better so that it's somewhat not prone to cheating. Maybe change some of the curriculum so that it's not prone to cheating. I mean, there's so many ways. Maybe have more parental accountability. What the majority opinion is saying is that whenever there's a problem, don't just rush to restrict the First Amendment. Try other methods first, whether if it's accountability, transparency, reforming certain curricula. That's better than to say, well, we have a problem, folks. Our students are either causing ruckus, or there's some kind of detrimental situation for the students. I guess we have no choice but just to restrict their speech, because once you open up the Pandora's box, then I think the outcome, while it might be good intention, later on you're going to build a precedence where now the school essentially runs your life, right? Because again, think about it. When a minor child goes home on weekends, opens up his or her smartphone, goes on to Snapchat, well, now are you trying to tell me that everything that student does is within the purview of the school. I mean, that seems like a very overreaching concept. And this court is very wary of that. So I think you're diagnosing the right problem. I mean, these things do exist. I think no one is denying that cyberbullying, cheating, other bad behaviors don't happen. I mean, that's part of public school, right? I mean, that's what kids do. But unfortunately, the remedy to that problem, those societal ills, should not be just rushed to restricting free speech. Let's see what else they can do. I think that's really the court's approach. And the courts will probably say, look, we're not legislators. We're just a bunch of people wearing black robes. We just call balls and strikes. So for us to say, well, this is good, that's bad, that's not the job of the bench, because that would be like an activist court. Their job is to simply, strike down unconstitutional governmental actions. And I think that's what they did here. Sometimes people are very disappointed when you see the court's ruling. It's very kind of like a passive, either approval or rejection. I think some people expect the court to give a more kind of a ferocious, proactive prescription, if you will, for a lot of the problems that we have. But you'll notice that a lot of these court opinions, they tend to kind of punt it down the road a little bit, and they punt it back to Congress. Why? Because we have separation of powers. Okay. Tara has a question. Go ahead, Tara.
So wouldn't, because you were pointing out and someone else pointed out that this could be an issue down the road when it comes to cyberbullying and things of that nature. But isn't there a distinct difference in the sense that this was someone, albeit she was talking about an entity and like a specific entity, she wasn't talking about a specific person, as opposed to cyberbullying, which would be a different type of, that would be a harm on an actual person as opposed to harm on, I don't know, an institution's reputation or something, in the sense of, F my school or blah, blah, blah. Because she didn't name anyone specifically, as far as I'm aware. I mean, correct me if I'm wrong. She was talking about like the school in general, the cheer in general. So it wasn't like she named the coach or the head cheerleader or anything like that. So wouldn't that, of course, be the difference as far as further down the road when it came to maybe cyberbullying or things of that nature? Because cyberbullying would be maybe more targeted towards a specific person.
Yeah, that's a great question. So I'm reading the opinion here, and they actually quote what the student posted on Snapchat. Quote, F school, F softball, F cheerleading, F everything. And then she does like a lot of, middle finger gestures, back and forth, and just plenty of F-bombs thrown around. But I think Tara's question is she direct it at any particular person? I mean, you could imply that when she says F cheerleading, that was directed at the cheerleading coach, since I guess the coach was the individual that was in charge of either accepting or not accepting her onto the cheerleading squad. I mean, you could certainly make a lot of assumptions like that, but ultimately, I'm not sure if this was directed at anyone, but the majority opinion does point out later on by Justice Breyer that, look, it's a vulgar language, but it wasn't like fighting words. And fighting words, by the way, it's a term of art, because there are a lot of cases where in the Supreme Court, someone, like a man walks up to another man, gets into their face, starts shouting, and, is that type of speech protected? And the court said, probably not, because what that person is about to do is incite violence. So that kind of fighting words usually is not protected speech. But in this case, at least what the majority opinion says is, look, it's very offensive. Yeah, vulgar language, yes. But guess what? Adults also use vulgar language. So how is it different if an adult uses it versus if a minor uses it? Yes, granted, minors are still subject to certain school rules when they're present in the classroom, but the fact that it's vulgar doesn't just automatically give you, an open-ended authority to then regulate speech. And I think that's really what the court's getting at. But look, cyberbullying is a real issue. I mean, there are cases and cases of teens committing suicide for cyberbullying. And what this majority opinion would do, what they would say, at least, if this hypothetical case came up, is, look, if you are a victim of cyberbullying, you have other remedies at hand. You could call the law enforcement, you could get a lawyer, you could talk to your principal and seek some kind of enforcement or injunction. And that's what the court would prefer to do rather than, just simply restrict speech. I mean, look, other than if there is a such thing as a Snapchat cop, where you just call the cop at Snapchat and they run over and they take some kind of disciplinary action. Of course, I'm being facetious because there is no such thing as a Snapchat cop because these things are very loosely monitored. And the whole thing about the concept of Snapchat is once you post something, it is supposed to just kind of automatically purge. So, it's like a new territory of technology that we're going into where I think the law really has not caught up yet. And again, credit to Justice Thomas, he does bring up a lot of these, gray areas of technology and law. Okay. I guess if there isn't anything else, we'll move on to the next First Amendment case. And this involves free exercise of religion. And this case is captioned Fulton versus the city of Philadelphia. And I guess before we get into the merits of the case, I'll just make a brief general comment, because what this case does in 2021, it picks up from where the 2018 case of the Master Cake Shop case left off. And for those of you who did not follow the Master Cake Shop case in Colorado, you had these bakers in Colorado who said, look, we make cakes for everybody, but we refuse to make wedding cakes for same-sex marriage because that violates their views on traditional marriage. So they refused to bake a cake for a same-sex couple. That case went all the way up to the Supreme Court. And that case, we did not get a substantive ruling because the court kind of punted it a little bit. And they said, well, we're not quite ready to decide on this case yet, because it appears that before the case made its way up to the Supreme Court, the Colorado State Civil Rights Commission should have done a better job just gathering the facts. And it seems like the Civil Rights Commission of Colorado was a bit biased towards or in favor of the same-sex couple. So they should have done a more kind of neutral investigation. So they kind of punted the case back down to the lower courts, saying that, do further investigation and see if it was indeed a true, genuine violation of the civil rights. So that was the Master Cake Shop case from 2018. Again, we go back to 2015, Obergefell, versus Hodges. Again, it's a very landmark case in the sense that it permitted same-sex marriage in all 50 states. But, for those of you who are pro-LGBT, you will celebrate that case in the sense that it legalized same-sex marriage. But then there was another kind of set of challenges now that we have, because now we have two competing forces again. We have the religious liberties, meaning if you want to exercise your own religion, and that's permitted, there should be no restrictions placed under the First Amendment. And then we have the competing forces of the civil rights, of protections afforded to same-sex couples, etc. So when those two competing forces meet, then how will the court decide that kind of a case? And when the Obergefell decision was handed down in 2015, it was almost unavoidable that this type of scenario would eventually surface to the Supreme Court. So that's what we have with the Fulton case. It takes place in the city of Philadelphia. It's the Catholic, it's called the Catholic Social Services, CSS. So what happened in the city of Philadelphia is that because the goal of the city was to increase adoption throughout the residents of the city, they had contracts with various different social agencies to foster and facilitate adoptions. And after the Obergefell decision, which permitted same-sex marriage, the city of Philadelphia then told these organizations, look, if you want to do business with us, you have to certify that you will permit adoptions for same-sex couples. Now, we have this organization called Catholic Social Services. They've been working with the city for about 5 decades. and they say, hold on a second, we have some major religious objections based on certain Catholic tenets of our belief. They subscribe to the conventional notion of marriage, one man, one woman, and they have some moral objections to letting children then get adopted into same-sex couples. So that really kind of sparked the litigation, and it went all the way up to the Supreme Court. So that's kind of where we are right now. Let's take a pause right there. Does anyone else want to comment on where we are right now on the case before we get into the opinion? Let's see. I see a hand up from Nirav. Go ahead.
I just wanted to clarify, was it, I thought they had an existing contract that the city was trying to terminate early as opposed to renewing it?
That's a good question. I know that the Catholic Social Services, they had a long-standing relationship with the city. I'm not sure if they were about to renew it or if the city wanted to terminate it. In either case, the Catholic Social Services wanted to continue the program, but
Yeah,
they,
I thought it was kind of relevant to the decision because, like, if they were, I know you'll get to this, but since it was kind of narrowly decided, but unanimously, that if it were a contract renewal as opposed to an early cancellation, it might be a different outcome.
good point. That's an important fact that's probably salient to the case. If I had to guess, again, I didn't read the lower court opinion. I think it was a contract renewal as opposed to termination. Just based on gleaning at the case right now, it's kind of hard to say, but let's suppose for the sake of this discussion, it was a renewal, because I think what I recall is that the city wanted like certification from all the agencies that it does business with, saying that we want certification, saying that you are going to allow these conditions, including the adoptions of same-sex couples. And I believe that's when the Catholic Social Services objected. So that's my understanding of the case.
I have a small question just before you go forward, because I just some clarification, if you will. The city of Philadelphia, as a government service, right? They are required to abide by discrimination, like anti-discrimination laws, like federal laws, yes?
Yes, correct, because the city of Philadelphia is a governmental subdivision of the state of Pennsylvania. So whenever there's any state action, whether if it's the city, county, or the state, it is subject to anti-discrimination laws, correct.
Then it would make sense that they would require any and all vendors that they contract with to abide by those same standards, at least in my mind, if that makes sense. It just would make sense to me that a government agency would require their vendors to abide by the same federal laws that they're abiding by in that work. Or I'm sorry, am I am I off? Let me know.
Sure. Tara's question is really getting to the crux of the case, which is, okay, there's this new law that was passed effective 2015 because of the Obergefell decision, which is same-sex marriages must be honored. And we live based on the US framework. We also have constitutional assurances that a judgment from one state will be upheld in another state because it's full faith and credit. So therefore, this should be permitted throughout all 50 states. That is true. So we have that implementation going on. But on the other hand, you have this charitable or this religious organization saying, hey, look, we have our First Amendment rights. And our First Amendment rights say that we are permitted to exercise our religion as we see fit, as long as it doesn't violate certain provisions of the law. And what Tara's question is getting at is when those two things clash, well, who wins? It's almost like, picture this as a game of baseball, right? When there's a runner and a ball, when there's a tie, well, who does it go to? Does it go to the runner or does it go to the person who threw the ball? Well, in the game of baseball, the tie goes to the runner. Extrapolating that example to this case, you have those competing interests. You have, civil rights protection, same-sex marriage, and you have the religious liberties. And those two competing forces in the eyes of this court are fairly equal. But when things are equal, this majority opinion says you have to side with religious liberties. And let me just illustrate some other cases, because that's going to really get to the heart of what Tara is asking. All right, imagine this, okay? Imagine that there is some religious denomination. They're saying, we consume peyote cactus. Why? Because peyote cactus is a hallucinogen. When you take it, it really enhances your spiritual awareness. And that is a religious sacrament that this particular religion requires to consume as part of its worship services. Is that a valid reason to then take peyote cactus? And I know that sounds like a very kind of loosely, loose summary of like a hypothetical, but that's actually a case that came out in 1992. It's called Division of Employment of the State of Oregon versus Smith. They call it the Smith case, basically. And in the Smith case, you had these members of indigenous tribe, and they argued that, look, as part of our worship services for our religion, and by the way, for them, that was their deeply held views on their established religion, that this is what we do. We take peyote as part of the worship services. And I believe Mr. Smith was working for some kind of a clinic, and when he lost his job because his employer found out that he was taking peyote, then he sought unemployment from the state of Oregon. And the state of Oregon said, I'm sorry, Mr. Smith, if you were just, let go of, maybe you would be eligible for unemployment, but because you took peyote, no, we can't really allow that, because now we are condoning an illegal activity, which is consuming of psychedelics, which is a controlled dangerous substance. So that's what the Smith case is all about. The Smith case essentially said, your right to practice religion will be permitted as long as you don't violate certain laws. And because Mr. Smith's consumption of peyote violated the laws of Oregon, I'm sorry, we're going to uphold the government action in denying your eligibility for unemployment. That's the Smith case. Here's another example for you, okay? Let's just say if a particular denomination, as part of its worship services, they sacrifice live animals, put them at the altar, cut them up with a knife, you open their organs, and then you celebrate, and you let all the blood kind of splatter everywhere. And that's part of the religious worship service. I know I'm kind of exaggerating a little bit, but again, some religions, animal sacrifice is part of their rituals that they do. So the question is, should that type of activity be curbed by the government? Okay, there's a comment from one of the members. Marty says, Santeria case, it was allowed. And you are absolutely correct. Thanks for pointing that out. So again, the court has gone back and forth in these cases. I think this case is the Church of Lukumi Baptist versus City of Hialeah, Florida. And this was a Santeria denomination, and sacrificing animal was part of their religious ceremony. And the court said, yeah, that's permissible. And whenever a government action tries to curb that, that's unconstitutional. And there, what they did was, look, when you look at your average people who go hunting on a recreational place, they do the same thing. They basically kill an animal, they open up their carcass, and they drain the blood, and they do all these things. How is that any different, just purely from the activity standpoint, than what this religious organization is doing? It seems like this law that was passed in this town in Florida was aimed at targeting certain religious organization. So they struck that law to be unconstitutional. Bottom line is, with the Santeria case, yes, animal sacrifice is permissible but again, I mean, there's limitations to it, but that's what this case is all about. So now we go back to this case, the city of Philadelphia. Here, the court did not. The court was not persuaded that the Catholic Social Services, their stated reasons that, look, we could only let adoptees be turned over to families or couples of traditional marriage. And the court did not buy into that argument. So that's basically kind of the crux of the case. Let's see if I have anything else here.
So what you're saying is the court basically said there are laws against discrimination, and what you're doing or what you propose to do is discrimination, and so no, it's not going to fly.
Yeah, basically. Again,
Okay, awesome, thanks.
Yeah. Well, I mean, look, the court acknowledges that, look, both sides have a very genuine, compelling interest, I mean, free exercise of religion is, without a doubt, the hallmark of the US in terms of, it's the First Amendment embedded right there. If you look at all of the, the past histories of how the First Amendment jurisprudence came about, just look no further than, the framers of the Constitution. So that's been well established, but now you have this competing interest of civil rights. So again, ultimately it's, liberty versus equality. And the court is saying, yes, both of those things are very important, but ultimately liberty will sometimes lead to certain discriminatory intent, but let it happen, because, we can't just try to block everything beforehand, like preemptively. You have to expand certain freedom up front, and then whenever there's a violation of it or infringement, then you could rule on a case by case. But if you just automatically curtail liberty, then that's a slippery slope, and this court was not about to touch that. Okay, Andrew?
Oh yeah, I think I put in the wrong reaction. But I wanted to say earlier, I feel like this will also infringe on like the child's rights on trying to get adopted or trying to increase the chances of getting the child adopted at least. But was that even considered with the case? Or I'm guessing with the summary we have now, it didn't seem like it was considered.
Yeah, so if I'm understanding your question correctly, I think you're asking if the goal of this relationship between the city and these agencies is to increase the adoption rates, then shouldn't let that interest prevail over anything else. That's true. But at the same time, what the Catholic Social Services is saying is that, yes, we are willing to be part of this citywide goal to increase adoption, because again, having families is better than having no families, because you're going to have a lot of orphans. But what the church is saying is we're taking a very principled position that we will not let them into the non-traditional families. So that's the ultimate thing. By the way, the church also makes this kind of non-intuitive argument, which is they're saying that even if the child was openly gay, let's say, they would still not let them be adopted to gay parents, because the whole thing is, well, maybe it might look like you're matching, a child who is openly gay into like an openly, gay, single-sex family. At the same time, they just don't believe this Catholic Church services, social services, don't believe in that institution. So that would go against their moral views. So. Okay.
I have a question. I do apologize for this particular case. Was any mention made of whether or not they discriminated against single people as well for this, or was this just solely about them potentially discriminating against same-sex parents looking to adopt?
Yeah, it's the latter. They're solely focused on single-sex couples, single-sex marriages. So I don't think that they brought up any like individuals, I guess non-married individuals trying to adopt. And I'm not really sure what the Catholic Social Services position would be. because I guess by definition, if you're a single person, you're not in the marriage. So I'm not sure if they would object to that, but they just, again, their definition of marriage is the traditional definition, so they objected to it.
Thank you.
Oh, by the way, just the opinion does conclude here that, look, whenever there is a government action that infringes on First Amendment, we use the highest level of scrutiny, which is the highest level of judicial review. And basically the government, must step up and say, well, we're imposing this government action because it is necessary, number one. Number two, the manner in which we are implementing the government action is very narrowly tailored. So that's actually a term of art, which basically says it's a such narrow in scope. It's not like a broad, oversweeping action. It's a very narrowly focused action, specifically designed to address the compelling and necessary governmental interest. So here the court is not convinced that, yes, we applied the strict scrutiny standard when we review this case, but we're just not convinced by the city of Philadelphia's purported reasons. So it's unconstitutional. Okay, there's another question from Ncaa. Go ahead.
Yeah, so maybe two questions. So first is, how do you think they managed to get a unanimous decision out of this, considering that I think going into it, people had assumed that this would split along left-right lines. And secondly, given what you just said about strict scrutiny, how do you see this case being applied to other cases with, more different fact patterns, not adoption, not same-sex couples, but where, for example, a government entity is trying to, contract out a specific service, and let's say one of the bidders for that contract basically says, well, it's against my religion to do a key part of the contract, but you still need to select me because otherwise you would be discriminating on the basis of religion.
Yeah, that's a great question. So what Nirav is inferring in that question is that, look, maybe this case was kind of narrowly decided, just strictly on First Amendment grounds. Okay, that's fine. Whether if you agree or disagree, that's up to you. But what we have here is now it's going to really open up the door, because it's almost unavoidable that you're going to have a floodgate of cases now saying that, look, it's against my religious principle to serve anyone who is not from the lower 48 states. So if you're from Alaska, Hawaii, Guam, I'm sorry, we cannot serve you, because our belief is that America, again, I'm just kind of being facetious and making this up, but these hypotheticals do sometimes make it all the way up to the Supreme Court. So if their religious belief is that, look, there's something sacred about North America. If you're not, native of the North American soil, then I'm sorry, but we cannot serve you. Or what if they say, I'm sorry, but I cannot serve certain individuals because of certain faith. Let's just say Jehovah's Witness. Why Jehovah's Witness? I'm just making that up. But let's just say we cannot serve members of the Jehovah's Witness faith because their professed faith is so antithetical to our deeply held religious beliefs. So we, in good conscience, cannot serve you pizza. Well, what is the court going to do? Again, this is really the uncharted territory that we're going into. And this case is very, in some ways, kind of narrowly decided as it relates to adoption. What this case is really significant for is when it comes to like adoption settings, like family settings, the court said, yes, the religious liberty trumps over civil rights. But you're going to have other examples in the future like this, where the court's going to have to address these other competing interests. And I'm just not sure which way it's going to go. That's a great question. We could just sit here all night, just think about all these hypotheticals, and I think in some instances, the court might just kind of, kick the can down the road just kind of dismiss it based on lack of standing or other technicalities. Remember, the court has its prerogative to pick and choose cases that they want to hear because they want to set precedents. So in this case, in Fulton, yes, religious liberty trumps over civil rights. The other thing too is, the Smith decision, the peyote case was not overturned because some people find that case to be objectionable, but the holding from Smith is still pretty much intact, which is basically, if you want to take peyote based on your religious beliefs, it's not permitted. And if the state action tries to prohibit you from doing that, it's permissible because it's a legitimate governmental policy. The law in itself is facially neutral, meaning it's not like targeted at Native Indians or other people of certain ethnic minority. It's simply saying you cannot take peyote. So I think, that's really the significance of the Fulton decision, is that those 2 points are really, become more crystal clear in terms of this free exercise of religion doctrine.
And there was my other question about like constructing a unanimous decision to get it narrowly decided. Like, how do you think that will play into, I guess, future decisions, or were you surprised by it being unanimous?
Let's see. Great question. Honestly, that's the question really involves what goes behind the scene at the court. I'll note that the decision was written by Justice Roberts. So one thing that you have to remember about Justice Roberts, again, I know we tend to look at these justices as they're just a bunch of legal scholars, they have a lot of experience. True, they do. And all of them are very, exceptional jurists, whether if you agree with their ideological views or not. But I think one thing that Justice Roberts has a pretty keen understanding of is that he understands the politics that go behind coalescing a majority. And if you look at certain decisions that he decides to write in the majority, it's very noticeable that Roberts wants to uphold the legitimacy of the institution of the court. When Roberts first came in 2005, I think the Supreme Court probably had its lowest approval back then. And I think a lot of it was really tarnished by Bush v. Gore. Again, whether if you agree with that outcome or not, because that ruling effectively decided the presidential election of 2000, those on the losing side felt very bitter about it, and they really blamed the Supreme Court. Not to mention, it was a 5-4 decision based on the ideological appointments. So I think when Roberts came in, he understood that, look, this institution that he really admired is really going through its lowest reputational point right now. And he wanted to basically, regain the trust of public confidence. And if you look at the series of series of opinions that he has issued, whether if it's the original Obamacare ruling, which we'll get to next, it's the Sebelius opinion from 2012, where he said Obamacare was constitutional because it's taxing power of Congress. He'll find ways to piece together coalitions so that the ruling is not such a predictable 5-4. So to answer Nuraf's question, how did this become a unanimous? I think it's a combination of these jurists, by and large, whether if they're liberal, conservative, they do really give tremendous deference to the First Amendment. And in the recent Supreme Court memory, they're pretty deferential to, certain First Amendment protections. And I think here, Roberts, I guess he prevailed in building a coalition so that it's a, very supermajority. I think another trend that we're seeing, in addition to these competing forces that we talked about, again, civil rights versus religious liberties, another trend that we're seeing now is that the conservative justices on a bench are saying, well, in some instances, when religion kind of, intermingles with government, in some instances, that's okay. That's permissible. And we saw that with the Holy Cross case down in Maryland, where they displayed this huge, cross in the middle of a town in Maryland, and they said that was permissible because that's more like a historical landmark. You have cases where if you want to display the 10 Commandments, in some instances, it's permissible. In other instances, it's not, depending on the context. So you have these conservative justices who are more deferential to kind of going against the Establishment Clause. And what is the Establishment Clause? Basically, the First Amendment says that there shall be no law that establishes government-sponsored religion. The framers of the Constitution, while they emphasize the religious liberty, they're also very skeptical of religious interference with the government. And as Thomas Jefferson once famously said, there should be a wall of separation between the church and the state. And that's kind of been the jurisprudential philosophy for much of the US history. However, in the recent, I would say about 20, 25 years or so, you have seen this kind of rightward shift into permitting more religious entanglement with government actions, whether if it's display of religious symbols. A real hot topic right now is also certain subsidies that religious organizations receive from the government. Again, is that a public endorsement of the government of a religious organization? And that's a very intricate analysis. So that's kind of the trend that we're seeing now. And if this trend continues, especially now you have a very solid conservative majority, I think that's the trend that you'll likely see. Just look no further than Justice Barrett's work as a law professor at Notre Dame, as well as when she was sitting on the Third Circuit. She was very deferential to certain aspects of free exercise of religion. So I think once she becomes more prominent, you're going to see more opinions like this coming down the pipe. Okay, let's go to Marty, and then we'll move on to the next case.
Yeah, thanks. So I'm not sure if I understood what you said regarding the Colorado cake, the bakery, because it sounded like that the Supreme Court punted, I think was the expression that you used, and didn't come with a clear decision. I looked it up in Wikipedia for whatever that's worth, and I just posted it on the chat. And so it says a 7, and I see what, I'll let you read it and see what you think.
Yeah, I think the outcome is correct. But again, before the ruling was handed down, I think the observers of the court were expecting a very pronounced ruling saying that the cake shop must make the cake, or cake shop does not have to make the cake. That was kind of the outcome that a lot of observers were expecting. Here, I think, if I'm not mistaken, they look back at the case history. And again, the case kind of originated out of the Civil Rights Commission. And my understanding of the case is that the investigator on behalf of the Civil Rights Commission was very biased, and they did not let the owners of the cake shop have a fair hearing. So I think they remanded back to the lower courts. I think, let me see, the court did not rule on the broader intersection of anti-discrimination laws, free exercise of religion, and freedom of speech due to the complications of the commission's lack of religious neutrality. Yeah, that's precisely what my understanding of the case is, because the commission's investigator, I think, was very biased in terms of kind of favoring the same-sex couples and being very arbitrary towards the cake shop owners. So.
Right, but isn't the bottom line, though, that the Supreme Court essentially ruled in favor of the baker and said, you're correct, baker, you do not have to bake a cake for this gay couple because it violates your religious beliefs?
Again, that case was from a few years ago. My understanding was that there was no substantive ruling one way or the other. I
Okay.
think to Marty's question, the answer is no. I think they just basically, reversed and remanded back to the lower courts. Here it was the Colorado Civil Rights Commission saying, look, whatever you guys did during the initial fact finding, it was so biased. You guys need to do it in a more neutral manner. And I think the specific instructions on remand was that the Civil Rights Commission, must also listen to the cake shop owners' religious liberty interests too, because it can't be all about just only protecting the civil rights interests of the same-sex couples. That has to be, compared or, looked at in comparison to the religious liberties. I think that's how the case turned out.
Okay, because it says it violated Masterpiece owner Jack Phillips' right to free exercise, and they reversed the commission's decision. That's what the first sentence says. Yeah.
Yeah, you might be right about that. It's been a while since I read that case. I do appreciate you coming up. I'm going to read it once more, and then if I have an update, I'll let you know what the outcome is. But my understanding is that, again, there was no substantive ruling. And I remember when we talked about this case back in 2018, because, again, a lot of us were kind of expecting a ruling one way or the other. And the conclusion that we had was, look, this is just, one step in many, steps that we're going to see when it comes to these two competing forces. And truly, as soon as I cracked open this Fulton case, it almost felt like it's like a sequel, like a part 2 of the Master Cake Shop case, because it really picked up where that case kind of left off. So.
Yeah, I just want to add, to Thomas, to support your point, and I guess to address Martin's point, is that I think the commission that Colorado Commission violated the bake shop civil rights. It was not saying that, it was not ruling on whether the cake shop violated the plaintiff's civil rights.
Yeah, that's true. Good point. Okay, let's go to, let's see, Andrew has his hand up.
So with what we said with pretty much the court background, I mean, there is a more of a religious bias with this court now, since it is like a 6 versus 3 kind of setting. So is it agreeable to say it's more like a religious bias going on with this court now?
Sure, that's a good question, because again, you would think that these justices, they should be just neutral in everything, right? Because the whole idea is you want to decide the case on the merits, on the facts, and no ideological views. I guess in a very simplified world, that's how these cases will be decided. But I think what Andrew is implying is that, look, ultimately, these justices are human beings, and because they're human beings, they do bring into the court their certain personal views. And I know, for instance, Justices Alito, Barrett, and Roberts, they're very openly staunch Catholic Christians. So, how much does that translate into their judicial philosophy? I think the answer is quite a bit. Now, does that mean that they're going to just go out and wholeheartedly endorse religion? No, I think it's a bit more nuanced than that. But if the question is, are they biased? I think the right way to approach it, again, for better or for worse, is that these justices believe, and by the way, these justices also include Justice Breyer, who is also very deferential to free exercise of religion. They believe that that right trumps over anything else. Yes, equality, civil rights interests are also important, but ultimately, from their standpoint, the First Amendment rights have to be safeguarded, and sometimes at the expense of certain harms that might be imposed to those who are seeking protection under equality and civil rights. So I guess that's really the best way to summarize it. Yeah, so, again, I think this case, will certainly be a continuing saga of these two competing interests. And I just remember when the Oberbefell decision came down, I think a lot of people were celebrating, in the pro-LGBT community. Fair enough. But I think, sometimes these challenges, the obstacles from the LGBT community will certainly continue ahead because you have employment discrimination issues, you have free exercise of religion issues, and these are very hot button issues. And it seems like this court is not afraid to take up these cases. So, and I think now that they have a very solid majority, I think they're more prone to accept these cases. I'll just give you an example. So when a case is a petition first comes to the Supreme Court, you need a vote of 4 justices to approve to grant a writ of certiorari, which is to accept a case to the Supreme Court. I think before, when the court was more divided, when it was like a 5-4, I think some of these justices were very reluctant to take certain cases because you had swing justices like Justice Kennedy and then much later on Justice Roberts. Now it's a very solid 6-3. I think they're pretty convinced that, yeah, if the case really is worthy on the merits, I think they're more likely to take it because it's less risky. I mean, you might get a conservative opinion that might be fractured into multiple opinions, but ultimately, because it's a very solid conservative leaning court, I think they're more acceptable. They're more prone to taking these cases. Okay, I guess if there's no other question, we'll go on to the 5th case. There's 2 more cases. It's the Obamacare case and then the Voting Rights Act case. So the next case is entitled the State of California versus State of Texas. I'll just briefly summarize the facts of the case. This is yet another challenge to Obamacare. By my estimation, I think this is the 3rd official challenge in the Supreme Court. I think there have been about 8 different legal challenges mounted against Obamacare. But this is a 3rd case with a substantive ruling on Obamacare. So essentially, you have these like red state attorneys general who file suit saying that, look, Obamacare is unconstitutional because the individual mandate part of it, they found that to be objectionable. Just to take a step back, back in 2012, this is the Sebelius decision, which Justice Roberts wrote the majority opinion, 5-4. And that was kind of like a nail biter because that case was handed down on an election year when President Obama was on the ballot for re-election. And the question was, how will the court either uphold the law as being constitutional or reject it? And if they were to uphold it, well, will they uphold it based on this kind of broad notion of commerce clause, meaning that the Congress can regulate commerce within these borders of our country, or will it be something else? And the upholding of Obamacare was based on Congress's ability to tax. And they likened the individual mandate component of it to Congress's authority to tax. So because it's a tax component, rather than like a penalty, that law was upheld. And then there were a series of other challenges that were brought about against Obamacare. And then the recent go around on this California versus Texas was that by the time 2017 rolled around, the Congress was controlled by the Republicans. And basically they zeroed out the penalty component of the individual mandate. Before, you had to pay a penalty if you could not prove that you had healthcare coverage. But by 2017, that penalty component was zeroed out. So there was no more penalty. So essentially these red state governors said, well, look, if there's no penalty, I guess that means this law is no longer, workable. And if it's not workable, then it's a 2-step process. One is because it's zeroed out, this law is no longer applicable, right? Because again, why would you have a zero penalty law, right? Usually if there's some kind of law, there are repercussions for violating the law. Here, there's zero penalty. That's number one. Number two is that the individual mandate is part and parcel of Obamacare. I mean, that is really at the heart of what they try to achieve. if you look at the legislative history of how they passed Obamacare, it was to increase the enrollment, to reduce the cost of healthcare premiums. So because this is at the heart of Obamacare, now that the penalty component has been zeroed out, well, it leads to the logical conclusion that the individual mandate is not severable, meaning it's attached whole in part of the actual Obamacare law. So you cannot just simply, sever that part of it from the rest of the law. So therefore, if this is unconstitutional, the entire law is unconstitutional. Therefore, we should just throw it out, strike it down, it's unconstitutional. Well, the district court in Texas, they found that argument to be persuasive. So that from there, the case made its way up to the Supreme Court. And interestingly about this case, let's see, the case got tossed out on technicality. So the court did not readdress the merits of whether if individual mandate is constitutional or unconstitutional. The court said, look, that ship has already sailed. That was decided back in 2012. That's permissible taxing authority by the government. And now we're left with these, certain governors of red states to see if, if they have even a standing to come to the court to argue this case. And standing is a very kind of technical ground. It's more like a procedural reason for either accepting or denying their place in the lawsuit as petitioners. Here they're saying, look, in order to have standing, you must have some type of a traceable injury. It has to be concrete, traceable injuries. It cannot be just, some kind of like an ideological objection. You can't say that I disagree with some environmental, policy that was passed by some administration because it violates your ideological viewpoints. You have to show concrete injury that is traceable. And here what the court did was, sorry, but there's no traceable injury because when the penalty is 0, well, that's not traceable. So on that ground, the court said, we're going to have to deny your standing because there's no concrete injury, there's no traceable injury, etc. So that's pretty much the gist of the case. It does kind of go into a lot of the nuances of, how they came about with the individual mandate. But the crux of the case really comes down to, look, Obamacare, whether you like it or not, it's kind of the law of the land. Yes, some of the provisions have been gutted. And I know there are plenty of attempts by the Republican-controlled Congress to repeal it, repeal and replace, right? But ultimately, this is the job of Congress. And because the prior ruling in 2012 upheld the law as being constitutional, there's really nothing further to really decide on the merits. So dismissed. Any questions on that case? Okay. I guess one thing I'll note, again, I was pretty surprised to see this. The majority opinion was authored by Justice Breyer. Justice Barrett also joined in on the majority. And I was surprised to see that she actually, concurred with the majority, meaning, to dismiss the case on standing. Because if you look at her previous writing, as a law professor, as a very esteemed jurist, she was very critical of Obamacare. So I think a lot of people who are watching this case very closely were expecting that Justice Barrett would, strike down the individual mandate as being unconstitutional, but she just simply said there's no standing. So for what that's worth, that's the case. Okay, so I guess if there's no other questions or comments on the Obamacare case, we'll get to the last case. And, this is a bit contentious because it involves, partisan elections. And, I know we just got over the 2020 elections, but, Voting Rights Act has kind of been, litigated quite a bit recently in the Supreme Court jurisprudence. Before we get into this case, I guess a few kind of general comments I'll bring up and then we'll dive right into this case. There's the 15th Amendment, which obviously is really at the heart of what we're talking about. So there's the 15th Amendment, and then there's the Voting Rights Act of 1965, and then there were the amendments to the Voting Rights Act in 1982. So those are the three key things at play. So again, the 15th Amendment basically is one of the post-Civil War amendments that guaranteed the right to vote, regardless of your status of your race, color, servitude, etc. And the idea is that once everyone is free, they're permitted to vote. Well, we know what happened in the subsequent decades and centuries: Jim Crow, poll testing, and finding restrictive ways to prohibit African Americans from voting. So we now fast forward to 1965, and we have the Voting Rights Act, which is a landmark legislation authored by Lyndon Johnson. And it really put in certain requirements, especially for certain states who, I guess, for the lack of a better word, had a very bad track record in terms of giving access to the ballot box. So because of those past histories of discrimination, the Voting Rights Act guaranteed that everyone had equal access to the ballot box. And Voting Rights Act is a very monstrous legislation that permitted all kinds of jurisdictional criteria, the access to ballots, the right not to be discriminated. But later on in 1982, Congress found that, well, despite the massive legislation that was passed in '65, it appears that some of these places are still engaging in discriminatory practices. Maybe it's not discriminatory in its face, but it has a disparate impact. And what that means is maybe the policies are just kind of neutral on its first glance, on its face, but when they're applied in reality, well, guess what? Certain people are always adversely impacted. And that's the disparate impact. And usually those who are disparately impacted are persons of color. So in '82, they amended the Voting Rights Act. I believe it's section 204, I'm not sure which one, but it's the one that involves making sure that all the votes are properly counted. But that's really what matters, right? I mean, you could go to the polling station all you want, but if your vote is not counted, then that really is antithetical to the idea of representative democracy. So those kinds of things are at play here. Before I go any further, does anyone have any comments so far?
Yeah, I mean, I think the dissent was a very strong one by Justice Kagan. I mean, after this case, I don't know what's really left of the Voting Rights Act, to be quite honest. I mean, the Section 5 of the Voting Rights Act was decimated in 2013 in the Shelby case. And now with this case decided, I think there's nothing much left of it. I think this is probably the most consequential decision made by the court for this term. And because of the significant consequences that it will have for our elections as a whole for our country going forward, given especially how contentious our elections have become in the last several decades, this decision will definitely have an impact on those elections being fair and free going forward.
Yeah, those are great points, Ali. We'll certainly bring up the dissenting opinion by Justice Kagan, which is very blistering. This is one of those cases where I think the dissenting opinion will kind of get more coverage just because of such high level of criticism as opposed to the majority opinion. So that's the first point. We will also get into the Shelby County versus Holder decision from 2013. But before we get into all of that, I guess let's just take a step back for a second, because when it comes to, again, these cases are simply categorized as voter dilution cases, meaning if someone's right to vote being, their right being diluted. And that's where a lot of these contentions arise. So there's really two narratives. And unfortunately, these two competing narratives tend to be purely based on partisan ideological grounds. So you have one kind of like viewpoint of our society that, look, there's massive voter fraud. And because of the rampant voter fraud, there must be certain measures placed so that it kind of safeguards the integrity of the voting system. And if you want to have a true representative democracy, well, you got to have, voter integrity. I'm sorry, election integrity, so that there's no massive voter fraud. So that's on one side of the aisle. That's the argument. And if you look at the majority opinion led by, I think it's Justice
Alito.
Yeah, he goes at length about voter fraud. So that's one narrative. The second narrative is, look, there is systemic, widespread voter suppression. The name of the game right now from the other party is to simply restrict access to ballot box. They're making voting as hard as possible because one side has numbers, the other side does not. So one side, again, this is the Democratic Party. All they need to do is just simply show up on the voting day or to the election places or even vote by mail. And simply showing up by sheer numbers, they will have a prevailing majority. But the only thing that's blocking the sheer majority is the restrictive measures that are being placed in a lot of these red states where they're placing a huge burden on the constitutional right to vote. So those are the two competing narratives. And you're seeing this right here in this ruling where going into the case, again, Justice Alito authored the majority opinion. This was decided purely based on ideological grounds. He makes incredible amount of deference to, look, government has a legitimate interest. Voter fraud is a real thing. The two issues that we're talking about in this Arizona case, two issues. One is this notion of ballot harvesting. What that means is rather than each person dropping off their vote by mail ballot at the drop-off box, can they just give it to somebody? And then that person will be kind of like the intermediary, collect all the ballots, and then do like a massive, deposit at the proper location. So one is the ballot harvesting. The other one is this notion of out of precinct voting. And what that means is, look, sometimes you go to a polling site and your vote might be registered at a different precinct. And quite frankly, that does happen pretty often. That's not some kind of like a exaggerated situation. So you might go to a polling site and then you see all these different sections, and you just give them your address and they'll tell you to go to section 5 or section 10. Well, it turns out that your correct section based on your zip code is section 7. So then what? Does that mean your vote is simply tossed out because it was your vote was cast out of precinct? And that's really the question at hand with this case. And what the majority opinion does is it just goes through length about voter fraud. We have a legitimate governmental interest to make sure that everything is regulated properly. And it does, the majority opinion does acknowledge that yes, the right to vote is hallmark of democracy, but they talk about these incidental burdens, meaning if you want to go cast your vote, yes, there are some burdens. If the weather is bad, that's a burden. If you have to drive on average, let's say 5 extra miles because you live in such a rural district, that's an incidental burden. Do you have to sometimes take time off from work to go vote? That is incidental burden. So the majority opinion says, yes, it's a constitutional right guaranteed. However, it does not mean that you have unfettered right to have equal access to the ballots. There might be some burdens imposed, and that restriction imposed by the government is legitimate. It's a reasonable governmental measure. It's very narrowly tailored, and it is legitimate governmental interest. So it's a very lengthy opinion, but at the crux of it, it just pays incredible amount of deference to curbing the alleged voter fraud, and the government has a right to regulate to minimize voter fraud. So that's kind of the majority opinion. Then we get into the dissenting opinion, which Ali had mentioned. It's very blistering. Ali, if I could put you on a spot, anything that's worthy of quoting from the dissenting opinion by Justice Kagan?
I think what's worthy that stood out for me is that she said that elections are often fought and won at the margins, which is really the crux of, the importance of this case is that, the majority opinion talks about incidental burdens. Well, what's incidental to one person may not be incidental to another person, especially based on their education, employment, and their income, which usually disparately impacts minorities. Throughout history, that's been proven to be the case. And it seems just that the majority has just completely ignored that history when, giving this huge deference. And I was just like wondering, given that history and given the jurisprudence that says that if you're dealing with a fundamental right, which the right to vote is a fundamental right under the Constitution, then the jurisprudence of the Supreme Court up until now was that you have to have a compelling state interest that is least restrictive. And the court just seems to like forget that. The majority seems like, well, as long as it's just a, strong interest, it doesn't have to be even compelling. It just has to be a strong interest, and doesn't have to be the least restrictive when you're dealing with a fundamental right that is subject to strict scrutiny otherwise. And the court, the dissent says, the majority is coming up with this multi-factor test that is not in the statute. In other words, what is really quotable is Justice Kagan says that the majority's opinion is based on a law-free zone. It's in a law-free zone. They're just coming up with these made-up factors like what is usual burdens of voting. That's not in the statute, and that limitation exists nowhere and is not justified anywhere in the language of the Voting Rights Act. The Voting Rights Act was meant to be read as broadly as possible to prevent any subtle form of discrimination, because nobody can do it outright, saying blacks can't vote. Nobody can say that in this day and age. So of course it's going to be a subtle form of discrimination, but the court seems to think that, those are bygone days and, that's not a problem anymore. And I think Justice Ginsburg in her dissenting decision in 2013 saying, look, just because there is no discrimination doesn't mean doesn't exist based on enforcing the law. It's like taking the umbrella and closing it up and you're saying that, well, the umbrella kept me dry, so that means that there isn't any rain coming. It's kind of like similar logic here that the court is using, at least the majority opinion. So I found that interesting.
Yeah, I know Andrew has his hand up. We'll get to Andrew in a second. I want to just pause on Justice Kagan's dissenting opinion and just briefly touch on the Shelby County versus Holder decision from 2013, and just kind of using that umbrella analogy. What the majority opinion from 2013 in striking down certain provisions of the Voting Rights Act said that, look, maybe umbrella was needed at one point because it was raining, but now there's no more rain, so we don't need umbrella. And the way how that metaphor could be extrapolated is that there are about 15 states who needed to get pre-authorization, or they call it the pre-clearance from the federal government. And these are like the southern states, and I think Arizona was one of the 15 states, because of the past history of discrimination that's been well documented. The Department of Justice said, look, if you want to have your own state election laws, that's fine, but we just need the pre-authorization to make sure that you do not engage in the discriminatory practices of the past. And what the 2013 case was all about is that this is unconstitutional, because I think that was authored by Justice Roberts in the 2013 case. He said, yes, voter intimidation, suppression was the thing of the past. That did exist, but that was back in 1965. By then, it was almost 40 years since, I'm sorry, more than 40 years, 53 years. Hold on, my math is off. Anyway, it's been decades since 1965 legislation was passed. And the challenge there was that they were using an outdated set of data from a long time ago, and now they're still trying to apply this now in terms of satisfying the pre-clearance requirement. They're saying that the data is outdated. If you want to use data, use more updated data. And what Justice Roberts telegraphed is that, look, if you use a more recent data, it's going to show that there is no voter suppression because pretty much everyone has access to the ballot box, notwithstanding the incidental burdens. So that's number one. Number two is the majority opinion in 2013 used the federalism argument, which is the 10th Amendment. Basically, these things are left for the states, and the election laws are state-based laws. So for the federal government to then come in and mandate these pre-clearance requirements, that's an overreach. So essentially, the key provisions of the Voting Rights Act was gutted based on those two grounds. So now that we come here, and they're saying that, okay, first of all, according to the majority opinion, voter suppression doesn't exist. If it exists, it's just an incidental burden. And the previous Shelby County case already decided that, because of the federalism that we have in the US, states should be left to their own devices to establish their own criteria. And if you want to impose any measures for these 15 states to be compliant, then you better have more reliant, more recent data. So that's kind of the holding. So that's, again, the Shelby County and then the current majority opinion. The thing that's really blistering about the dissenting opinion, Ali already mentioned a few of the points that Justice Kagan brings out, but it really does kind of like a trip down the memory lane of, I think she quotes here, a single statute that reminds us of the worst of America is the Voting Rights Act. And again, these are kind of like the incidents of the badges of slavery. Again, 14th, 15th, 16th Amendments emerged as a result of the Civil War. The fact that we're still litigating over certain components of the Civil War kind of shows some of the worst part of America is still alive and well. Whether if you agree with that, that's certainly up to your interpretation, but that's what the dissenting opinion says. And then she quite literally, goes down the memory lane of, John Lewis and the Edmund Pettus Bridge and how, their movement really kind of fostered the enactment of the Voting Rights Act. And let's see, there's some other blistering points. Here's another, sorry?
Yeah, no, I would just saying that the fact that she said that the majority's opinion about Section 2 of the Voting Rights Act, the relevant section at issue, was a law-free zone. I thought that was pretty blistering in itself, that they're just coming up with made-up factors to justify restricting Section 2 of the Voting Rights Act, like they did with Section 5 in 2013 under the Shelby case.
Yeah. Then she talks about, the American greatness. And again, the hallmark of American greatness, which is, the pillars of our democracy, is representative form of government. And this is where she says, what is tragic here is that the court has yet once again rewritten in order to weaken a statute that stands as a monument of America's greatness and protects against its basest impulses, meaning discriminatory practices. So here I think, this is a very blistering opinion because usually justices are very restrained when it comes to criticizing, the fellow members on the bench, but, this is pretty clear. Just to go a little further into the dissenting, again, a lot of the historical context, the democratic ideals in America got off to a glorious start. Again, that's talking about the Declaration of Independence, the Constitutional Convention, but the democratic practices, not so much. Meaning, in theory, it's a great concept. All men are created equal. You go through all the Bill of Rights, but in practice, was that ever enforced uniformly or equal justice under the law? And at least Justice Kagan says that's not the case. Again, then she talks about Congress enacted the Voting Rights Act to address a deep fault in our democracy. Again, the idea is that if democracy is America's greatness, that's kind of the pillar of what this, nation is all about. Well, there's a deep fracture along that pillar because a huge segment of the population who are systemically disenfranchised. So that's what she says. And I think the last page of the opinion is pretty much the most blistering, because she doesn't really say it outright, but she does kind of like hint at the authors of the majority opinion saying, okay, so when you talk to a lot of these like Justice Gorsuches and Justice Thomases and et cetera, you know, they're originalists, textualists. So basically, look, if the Congress enacted the law, then let's just go by the congressional intent, right? So let's not be judicial activists and try to override the will of Congress, because ultimately it's their job to draft legislation, pass it, and tailor it so that it serves their constituents. So what Justice Kagan says in the last page of the opinion is saying, look, let me just read it here. At least the majority of the opinion should treat the Voting Rights Act as if it were an ordinary legislation. The court always says it must interpret a statute according to the text. Textualists, right? She's specifically singling out textualist jurists. That it has no warrant to override congressional choices. So if you want to override congressional choices, well, guess what? By definition, you're being anti-textualist jurist. But it says the majority of the opinion today flouts these virtues of being a textualist, but they're abandoning that principle now because they want to gut certain portions of the Voting Rights Act. Just one more point, and then we'll open it up to others. And this is really the blistering part, because she stops short of calling the majority's opinion an exercise of judicial activism. The last paragraph, this court has no right to remake Section 2 of the Voting Rights Act. So again, the legislation is already there. It's been proved duly by Congress. It's been enacted. It's been in place. Now the majority is coming in and they're gutting it. And effectively, by them gutting it, the majority, they are remaking Section 2 of the Voting Rights Act. She says that's not the job of the bench. That's the job of Congress. And basically, she's calling this a classic example of judicial activism. Like, if this is not judicial activism, I don't know what is, because when you're trying to override the will of Congress, well, that is something we need to take notice of. Just last point here. Again, the hallmark of our constitutional system is balance of power, meaning one branch of government does not have a monopoly on power. There's checks and balances to ensure that there's no government overreach from one branch. And the last paragraph basically says that law, being the Voting Rights Act, of all laws, deserve the sweep and power of Congress that it originally gave. That law of all laws should not be diminished by this court. And what she's saying there, Justice Kagan, how dare this court simply rewrite the legislation? Again, this is not some little minuscule legislation that deals with some administrative law or some bankruptcy code. This is a monstrous Voting Rights Act that probably affected millions of US citizens. So how dare we, as the members of this bench, again, we're supposed to be just a bunch of people wearing black robes, calling balls and strikes. But now they're effectively rewriting Section 2 of the Voting Rights Act. So it's a very blistering dissenting opinion. If you read between the lines, of course, they don't go out and do name calling or that kind of thing. But when you look at these kind of stylistic points that are made, it's a very highly charged opinion. So that's pretty much how the case ended up being. Okay, any questions or comments?
I have a few.
Okay.
So, I find it interesting that, Republicans, the Republican attorney generals in the last election that just concluded a year ago felt so strongly about democratic states, democratically controlled, state governments, that how they ran their elections, this past, election cycle was so egregious that they had to file a lawsuit with the U.S. Supreme Court. This was, I think, Texas versus California or something like that. And the court didn't, the Supreme Court didn't take it up, but the Republican attorney generals felt so strongly that they felt they had to intervene on how other states conducted their own elections. But, in this case, when, their own, laws are being subjected to scrutiny, within own Republican controlled houses of government, and for example, here in Arizona, then, that's hands off. We can't question the election laws of Republican states, but we can question the election laws of Democratic states because they're fair game, but not ours. I just find the hypocrisy. I'm not surprised by it, but I'm just wondering when the Supreme Court is going to put 2 and 2 together, if ever. I don't think they're not in that business, but it would seem clear to me from their decision not to take that case from last year, Texas versus California, versus this one. They wanted to, clearly indicate that, their tilt towards, more restrictive voting in general, because right now the concern for restrictive voting, I think, is more, a pressing issue than it ever was since 2013 when the Shelby case was decided. We're here, the crisis of our democracy, if you want to call it that, is because of what happened in 2013. So for the court now to say that there is no crisis that we created back in 2013 to begin with, because we don't see the obvious, in your face racism that we think is necessary in order for a law to be struck down, I think is just tells monumentally about where the court's, jurisprudence has devolved since, the Shelby case was decided in 2013. That even after that, when the situation got so much worse, all these red states pass all these restrictive voter purging laws, voter registration laws after Shelby, and then to say that, no, we don't see the problem, we don't see any racism because it's not in your face, it's behind the scenes, so that's okay. We can continue to have discriminatory policies that affect disproportionately African Americans, as long as the state legislatures gives us a neutral excuse to say, oh, well, we want to combat a voter fraud issue that doesn't exist in reality. There might be some anecdotal evidence for it, but there is no widespread investigation or evidence for voter fraud. But we're going to take that and run with it and say that that's a strong reason. It's not even a compelling reason. And we're going to say that you don't need to make it the least restrictive form of voter dilution possible. You can have as much flexibility as you want in the state of Arizona, as long as you can give us a reason to justify upholding your law, which is very curious, especially since what happened in 2000 with Bush versus Gore. It's kind of like the flip side, the flip coin, where they intervened wholeheartedly in the Florida elections, but here they're saying, no problem here, no violation of your fundamental right to vote here, but 20 years ago in Florida, yeah, we found a problem there. I'm surprised they even mentioned that case in this particular case.
Yeah, all good points. Let me just address a few of them and then we'll move on to Andrew. First of all, Bush v. Gore, I know it's another election case in which the Supreme Court intervened. However, it's different from the Arizona case in that Bush v. Gore ultimately came down to the 14th Amendment provision for all the ballots to be counted equally, meaning if they received different treatment in terms of how they're counted, then that violated the Equal Protection Clause of the 14th Amendment. This case in Arizona deals with Section 2 of the Voting Rights Act, which again, it's like a very narrowly interpreted case where they're looking at two things: out of precinct and ballot harvesting. And to be fair, this case, the Arizona case, was based on the 2016 elections and not the 2020 election. So that's number one. Number two, I think the majority opinion, while they do show tremendous amount of deference to state regulations, they do cite that, look, ultimately it's based on the totality of circumstances, meaning this is not like a blanket oversweeping, decision to apply to other voting rights challenges. But given what we have specifically in Arizona, they thought that the governmental approach was reasonable. In fact, they go through lengths about how, voting is so easy in Arizona. You could vote 24 days before the start of the election. You could do mail-in ballots. You could do, late registration. I mean, they give like a whole host of reasons why the majority opinion thinks that there is a tremendous accommodations afforded to the voters. So again, whether if you believe that or not, that's the majority opinion. Finally, the Supreme Court, to their credit, they didn't really take up any of the election challenges brought on by, I guess, the Trump campaign. So I know there are about 32 cases that were filed in various district courts throughout the US, most notably Pennsylvania, Michigan, all the swing states. But I think the Supreme Court categorically just denied petition. So unlike the 2000 case where basically the Supreme Court said, stop the counting, we don't need to recount anymore. Here, I think the Supreme Court was a lot more restrained. And you might give that credit, if you think it's worthy of credit, to Justice Roberts, because he knows that stepping in and interfering with any kind of election outcome is highly objectionable to at least half the country. So for him to wanting to sustain the integrity of the court, I think it's to his wisdom. He probably told the associate justices, look, don't even intervene, don't even grant the hearing. This will be just dismissed. It was like a single page opinion saying dismiss, goodbye, that's it. And there's really no right to appeal. Once the Supreme Court says dismiss, like that's it. So
right, but I mean, I think that in this particular case that was decided by Justice Alito, the decision not to intervene will have a lot more consequence for further, election laws in other states, in other elections, as to whether or not the court should intervene in those particular situations. And with this decision, the court is giving its indication that it's not going to intervene in general, no matter what kind of restrictive voting laws are mentioned. And in particular, in Arizona, Justice Kagan said that Arizona is the actual national outlier when it comes to out of precinct voting. She said no one is even close compared to Arizona and into how many votes are purged as a result of this out of precinct voter restriction. So the fact that the majority didn't, really consider that, or just, bought the argument that this is a neutral law just because they said it's neutral, the Arizona said it's neutral. It just shows you that the lengths that this court has gone to say that racism really doesn't exist anymore in this country, that we don't really have racism, and that therefore laws are going to be upheld and the Voting Rights Act is pretty much useless. We don't even need that statute because what is left of the statute? Section 5, which the Congress passed a pre-clearance, as you said, that was really the teeth of the Voting Rights Act that prevented, stuff like what happened with the restrictive voters laws in the South. But now what was left was Section 2, which relies on civil litigation, which is an after the fact remedy. And even that is now out of the picture. So what's left? If Congress can't get involved and the federal courts can't get involved, unless you can prove, on its face racism, then, what is there left to prevent is a future state from passing more restrictive laws, just as long as they say, hey, we didn't intend to discourage any minority voting, even though it might have a disproportionate impact on their opportunity to vote compared to, white voters. We're still, that wasn't our intent. So, it's all good.
Yeah, if we look at things from a more macro level and look at certain trends from the Roberts Court, I think one defining point of the Roberts Doctrine, if you will, I'm not sure if there is such thing as a Roberts Doctrine, but if there is a hallmark of what Chief Justice Roberts is kind of a, jurisprudential aim is to kind of undo some of the progresses or advancements from civil rights. And you could go as early as 2005. There was the school desegregation case. It's the Seattle School District case. And basically, he wrote a very, poignant, I think it was a majority opinion, saying that, look, if you want to end racism, stop talking about racism. And basically, what he's telegraphing there is like, don't be so fixated on racism, because I think in his view, a lot of these civil rights struggles from the bygone era of the 1960s are no longer prevalent in 2005 or 2021. And I think a lot of his kind of like very precision judicial rulings have been about trying to undo some of the measures that were placed in from the 1960s in terms of the Civil Rights Act, the Voting Rights Act, et cetera. So when you look at the school desegregation case from 2005. There were a whole host of affirmative action cases that came shortly thereafter. And then now we have the 2013 case, Shelby County, and the Arizona case from this term. I think that is really his hallmark, where I think Chief Justice Roberts, he chooses his battles very carefully. And again, I'm not trying to say he's like a politician, but ultimately he knows that he's kind of threading this very tough needle, this fine needle, in terms of maintaining the legitimacy of the court, having some kind of a coalition around him. Yet at the same time, this kind of rock-ribbed conservative traditionalism is based on, trying to not be so fixated on government actions in response to the civil rights era. So I think that is kind of like his mantra in terms of his judicial philosophy. And I think he's really exercised with great deal of caution and restraint, where in other cases he kind of backs off, but in certain like hot button issues, especially on race relations, he, I think, really shows truly how he wants to shape this court. So again, whether if you agree or disagree, whether if you like it or not, I think that's going to be the trend. And again, the overall trend that we're seeing tonight is, you have these young justices, starting from Justice Gorsuch to Barrett. I think their age range is probably like 48 to like 55, I think. That is very young. And look, Justice Barrett, I think she was only 48 when she was appointed. If her predecessor is any indication of how long she's going to serve on the bench, I believe Justice Ruth Bader Ginsburg passed away at age 87. So we are likely to see Justice Barrett, again, provided that she's healthy and notwithstanding any other emergencies, she's going to be on the bench for at least 3+, if not 4 decades. So you could see how a lot of these, principles, these conservative doctrines that Justice Roberts has continued, I think that's going to continue on with these younger justices. So,
and whatever that means for our democracy will remain to be seen, I guess.
Well, look, to be fair though, these conservative justices will say, all right, you don't like this ruling? Go back to Congress and, rewrite certain legislation that will protect the right to vote. And there are ways to do that. I think what the conservative bench will say is this. First of all, the 2013 case was reliant on old data from the 1960s or 1970s. That's the bygone era of, segregation. We're past that, we're in the post, racial era, right? Because I think that's, the whole idea that once, President Obama was elected, we're kind of like in this post-racial era. Again, whether if you believe that or not, I think some of these justices do subscribe to that theory. And if you don't like this ruling, well, go petition your government and seek redress by getting some new laws put into place. That's what they would say. Again, is that the right approach? That depends on who you ask.
Well,
Okay.
yeah, the law was there for a reason. It was passed, and I don't think it's the 1960s data that is really at issue. It's what happened after 2013. That's really the issue. Is there's plenty of data after 2013 about voter restriction, and the court apparently doesn't think that data exists.
Again, I hate to be so disagreeable, but I think what the court's going to say is it's a case-by-case determination. Here in Arizona, the court found plenty of evidence that the access to ballot box was fairly easy, and that's what Justice Alito says. However,
Fairly easy for who?
well, okay, fair point. Because I know in Arizona there were some indigenous populations who had to travel like hundreds of miles to get to the ballot box. Fair point. So it's without a doubt that certain minority groups were disenfranchised. Fair point. But I think what the majority opinion will say is, look, let's just take things on a case-by-case basis. There's a reason why certain 15 states had the pre-authorization requirement, right? The pre-clearance. So let's say, for instance, I think Georgia is probably another good example because they enacted certain restrictive laws that said, well, you can no longer register people to vote on Sundays, right? Or you can no longer let people vote on Sundays. I think Georgia had this program, I think it was called Souls to the Polls, meaning, you go church services on Sundays, that's kind of like, the soul healing part. And then after that, you go to the polls. And I think, if I'm not mistaken, the state legislature restricted that soul to the polls program. And now you could say, well, that has a racially disparate impact because, Georgia has, large numbers of African-American voters. And usually a lot of them go to churches on Sundays. And now you're restricting their right to ballot box. I think if something like that emerged, this court might look at it differently because I think the majority opinion does telegraph that they are willing to look at things in totality of circumstances.
With additional factors that they came up with in that totality of circumstances.
Sure. So I think the majority would start out saying that, yeah, voter fraud is a problem. Yeah, there's a legitimate government interest. Yes, we have to give some deference to government actions, but does this have a disparate impact? And they'll go through the whole analysis, including things like, are they looking at the recent data? Have the past practices, of discrimination been eradicated? They'll go through the whole analysis and which side they will come out on. Something tells me that they'll come out on the pro-government action side, just based on this reading of the case. So, okay, let's go to Andrew, who has a hand up.
Yeah, so I think with what we talked about, there's yet again another representation of some kind of bias with this court yet again. I was coming to like a talking like if the main reason or worry is voter fraud, it'll probably be best if there were sort of like a financial update with these voting places in terms of updating the machines, in terms of they can make faster, like some kind of faster voting process so people can easily just vote and just leave and get out. But I guess this will go in between like a minor convenience of how this works as well. So yeah, I mean, I don't know if someone can say, hey, we have a case, and the case is, can we at least update the processing of our voting in terms of making it easier? But I guess this was it in a way. Yeah, I don't know what to say in terms of this, but I mean, I think the agreement is there is obviously a clear bias in terms of this court as well in terms of this situation of the voting rights as well.
That's a great point, Andrew. I mean, it's kind of like you know, like a public secret almost that in some corners on the Republican side, I mean, they kind of like, disclose the, I guess, dirty little secret, if you want to call it that, which is basically, look, if we let people just turn out to vote, then we're gonna lose. And look no further than, I forget his name, but he was the state of Pennsylvania, I think either leader of the Assembly or the House. In 2012, basically, this leader of the Pennsylvania State House supported then candidate Mitt Romney. And basically, they were just going down the list of things that they accomplished as the members of the GOP of Pennsylvania. And they're saying that, look, we oppose Obamacare, check. We oppose, restrictive voting measures, check. And then when he said we propose restrictive voting measures, he said, we propose restrictive voting measures so that Mitt Romney can be elected, check. And that right there kind of tells you what their modus operandi is. Now the question is that systemic wide practice throughout all these different states? And I would beg to differ and say it's a case-by-case determination. Yes, I think a lot of the red state governors and lawmakers are more prone to having that viewpoint of restricting ballot boxes, but I'm just not sure if it's like some sort of like a concerted effort for all of them to just kind of like collude and impose these restrictive measures.
Well, actually, from my understanding, Section 2 is supposed to say you look at the local conditions. So it's very specific. It's not looking at a systemic conspiracy. It's just saying, look, the local conditions on the ground based on the history, economics, socioeconomic conditions, is this particular law that's been passed having a desperate impact as to opportunity to vote, not necessarily as to the outcomes of voting, but the opportunities to vote. In this particular district, this particular county, does this law have a desperate impact on the opportunity to vote for minorities? And I think that wasn't done. They just took the Arizona's excuse on face value and say, yep, everything's good here. We have no reason to doubt what's going on here, even though Section 2 is supposed to be read broadly, if it's supposed to be read fairly. As Justice Kagan said, there is no limitation on its language and its sweep as to what is supposed to be investigated. They still thought that it was good enough.
Right. The name of the lawmaker that I was referring to in the state of Pennsylvania, it's Mike Turzai. I think he was the House Republican leader. And basically, look, maybe you could say it's taken out of context, but it's certainly kind of an open secret that, whoever has the most numbers will win. Hang on one second. Looks like the message that I posted didn't go to everyone. So, sorry about that. Yeah, check out this video. So anyway, I think that will kind of speak for itself. Okay, any final thoughts before we wrap up? We're almost at the 11 o'clock hour.
Thomas, you're muted.
Sorry about that. It's the 11 o'clock hour now, so we do need to wrap it up in a few, but why don't we just talk about the future of what to expect from the court, especially the next term. So I know with this term, it's kind of like a transitional, and you see a lot of, the shuffling of the ideological divides, especially on the conservative side of the bench. I think what we could expect from the upcoming term, 2021 and 22, is that number one, it's going to end when we have the midterm elections. So which means every opinion that's handed down is going to be analyzed with prism of partisan lens. Number two is, I think, based on the types of cases that are on the court's docket, I think the next term will be what I consider the Supreme Court classic. And what I mean by classic is they're going to do their typical abortion case, Second Amendment case, affirmative action case. So, these are really the most hot button issues by the court. And, there's already cases coming out, one from Mississippi on abortion. I think the conceal and carry case come from right here in the state of New York. And then there's going to be an affirmative action case from Massachusetts. So, right there, you have very contentious hot button issues that are going to be decided on midterm election year. So, any thoughts about what to expect next time?
Well, I think if any indication, precedent is debatable with this Supreme Court, as it has been for several terms now. With the changing of precedent, I would expect that, Roe versus Wade, 50-50 as to whether it survives going forward. As we were just discussing this Arizona case, just coming up with a whole new multi-factor test that's nowhere in the statute and ignoring clear Supreme Court jurisprudence as to fundamental rights, especially voting rights, the strict scrutiny standard out the window. So I wouldn't be surprised if, abortion regulations are also thrown out the window going forward. So, we'll see.
Yeah, I think it's a little premature to, discuss the fate of Roe v. Wade. But whatever the outcome is, if they're going to just drastically change it, I think it'll be more of a piecemeal approach where you're going to have a series of cases that kind of chips away at Roe v. Wade. I don't think you're going to have like a landmark decision that just simply overturns it. And just based on a lot of these judicial nomination hearings, best to my knowledge, I don't think any of these justices, Gorsuch, Kavanaugh, and Barrett, they were in favor of just outright overturn. They might have said something like, well, I believe in, pro-life, but ultimately I don't think they've said anything to the effect of it should be overturned, number one. Number two, I guess what I'm also looking for from the bench is what I call the Justice David Souter effect. And what that means is Justice Souter was appointed by President George H.W. Bush, I believe in the late 80s. And, he was supposed to be another, conservative addition to what was already pretty conservative court under Justice Rehnquist. Well, it turns out halfway through his tenure, Justice Souter, probably like in the mid 90s, he became more of like a centrist or even quasi-liberal on some issues. On some other like economic, issues, he was more conservative. So I'm just wondering if we could see a kind of a shift in ideology from some of these justices, and if so, who will that be? That's something I'm kind of keeping an eye on. I think Justice Gorsuch has shown his open-mindedness from his approach to his judicial philosophy as a textualist. And I think there was a case from the last term involving a transgender rights that he was really willing to, kind of go against the prevailing view of the conservative bench to be more protective of transgender employees' rights. So that's kind of interesting to watch. I think Justice Kavanaugh, just based on sheer numbers of his role in being a majority opinion, he might be more influential. So those are the kinds of things I'm watching for also. Okay, anything else before we sign off? Andrew.
Yeah, I do have to say, after this discussion, I think the biggest elephant in the room was mostly with the Roe versus Wade situation that will inevitably come up. I'm guessing after this talk, I'm a little bit more optimistic in terms of it seems like this Robert guy is trying to make sure things don't go obviously too heavy-handed on one side. Because I think if the worst situation would have happened with Roe versus Wade, I think it'll probably go down to like a really bad slippery slope in terms of no one would want to go down in terms of the government and how they want to dictate a person's autonomy. I do want to say, was the situation with like Facebook and the antitrust situation, was that dealt from the Supreme Court?
Yeah, I'm not sure if that's going to be heard during the next term's docket. I know there were some, I guess, lawsuits that came out of the 9th district, if I'm not mistaken, but I'm not sure if that's going to be heard, quite honestly. So I don't want to comment on something I'm not familiar with.
Okay, yeah, I thought I heard something in which there was an antitrust thing with Facebook, and the states were trying to sue Facebook, but they like disown it because they didn't have enough information to prove their case. So I was thinking they'll bring it back again this time, but it seems like from your standpoint, they're not going to do it again for this.
Yeah, I think the regulation of social media, notably Facebook, I mean, I think that's ripe for Supreme Court intervention. But again, Justice Roberts, he will pick and choose his battles wisely, because I'm not sure if he wants to necessarily pick that fight on an election year. Maybe he might, but I think he wants to, be more cautious. And right now, really the grievance coming from conservatives is that, look, social media is trying to, suppress conservative viewpoints. So it might come under like a free speech kind of like a class action case. It might come under antitrust. It might come under both. I'm not sure, but I think this Chief Justice is astute enough to, if he's going to pick the battle, make sure it's, fought at the right time, make sure he has the right, coalition of concurring justices. So I'm not sure if that's going to necessarily happen next term. And, a lot of times what they do is they will hear the case and just kind of reverse and remand it. And what that does is that just kind of punts the can down the road, and then it might come back up again, back from remand, and that's when they decide on the case. A classic example is the Citizens United. Again, the case started out as a very narrow case involving a documentary about Hillary Clinton, but then they recalled the case, reordered oral arguments, and it became like a very expansive interpretation of free exercise, of free speech and campaign contribution. So we'll see how this court goes. That's like a big mystery, and I'm sure if you go to a lot of these blogs that covers SCOTUS, I'm sure there's a lot of speculations about which cases the court will cover next.
But Roberts is not shy about his pro-corporatist agenda. So he may be on the social issues. So he doesn't try to thread the needle when it comes to corporate rights. So be aware of that as you're going forward about looking at his decisions. He knows not to step on the social issues because he doesn't really care about that so much as he does about the corporate rights. So
yeah, really quick, I feel like the free speech with social media is a really gray area, because yet again, these are like private platforms and they obviously have a TOS. So it's like I don't see the point why they would even go after this, to be honest with me, because of that situation. But we see, I guess.
Okay, I guess if there are no more comments, this will be the place where we leave it. I guess just my final comment, despite, some criticisms of the court, I do, believe that this is a very important institution. I'm so glad that everyone here was joining in this call, because I know the Supreme Court is sometimes not the most glamorous aspect of our government, but, they do serve a very important function. And I just wish that more people would be interested in what goes on at the court, because, a lot of these cases, on one hand, they do seem like an intellectual exercise back and forth, but at the same time, it really affects everyday people's lives. Things like,
especially the last one that we talked about.
Absolutely. So again, thanks once again for being on this call. I look forward to having another one next year when we talk about guns, abortion, affirmative action. So until that time, thanks. Be well. Take care.
Take care.
Alrighty. See ya.